The hearing is in the matter of CFR 045/2020 before Justice Wayne Martin and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimants are represented by Adil Shah Goddard, Middle East, LLP. Lead counsel is Tom Montague Smith, QC. The 1st, 2nd, 3rd, 4th, 13th, 14th, 16th, and 17th defendants are represented by Hadif and Partners. Lead counsel is Zoe O'Sullivan, QC. The 5th to 12th defendants are represented by Bestwins Law Corporation for Legal Consultancy. Lead counsel is P.V. Shaheen.
Thank you. Mr. Montague Smith.
Thank you, Your Honour. I'm afraid I didn't hear any of that, but I can hear you now. So if at any stage there's a problem, you may need to use the chat function for me because it's been in and out, I'm afraid.
Yes, all right.
Thank you, Your Honour. I appear, as you know, for the claimants. I am appearing with a junior, Mr. Watson. He's having trouble getting in and he keeps being ejected, so hopefully he will be here for some of it. You have, and I just need to be a bit careful, you've heard you've got Bestwins are on here for the 5th to 12th defendants. I did not hear, I'm afraid, the name counsel. I think it was Mr. Shaheen.
Mr. Shaheen? Yes, yeah, that's right.
That sounds right. And then you've got Ms. O'Sullivan and Mr. Harris-Bohr, and they are appearing for the respondents to the anti-suit and also the defendants. I can list them. They're the first 4 defendants, yes, and then the 13th, 14th, 16th, and 17th defendants.
Yes.
You have a letter from the 18th defendant, that's Spectrami. Yes. They're represented by Galadari. They support both of the applications that I'm making, but yes, they don't appear today. And then you, there are 2 other defendants. One is the 15th defendant who's never responded to these proceedings. And before Justice Cook, our position was that they had been served by delivery of notices to the first defendant as an agent. But just before the hearing back in June last year, we had applied for an alternative service order to serve them by email at various addresses. That wasn't determined before the stay was imposed, so they've never taken any part in these proceedings. The 19th defendant, slightly curious position, it's said by the Hadef defendants, if I can call them that, that the 19th defendant does not exist. However, they had previously filed an acknowledgement of service on behalf of the 19th defendant, and then they were applying to come off the record for the 19th defendant. And again, that application had not yet been determined before the stay was imposed. So you have before you either counsel or, in the case of Spectrami, a letter from all of the parties who have been participating in this action to date.
Yes, thank you.
Thank you. So you have today 2 applications, as you will have seen. The first is for an order lifting the stay, which was imposed by Justice Cook in July of last year, on 1st of July. And then the second is an application for an anti-suit injunction. Now, that application is directed at Dubai court proceedings, and those have been set down for judgment on Wednesday. And that is the reason, this coming Wednesday, and so that is the reason for there being a degree of urgency in relation to this application. And if possible, we would be asking Your Honour for a decision today, even if that means that Your Honour's reasons have to come later. I understand that Your Honour has already heard submissions on similar application to the application to lift the stay, and indeed has heard submissions from some of the respondents to this application. And Your Honour will also be obviously familiar with the Joint Judicial Committee itself and the legislation for that. And I know Your Honour sat on the McCann case. Yeah. Your Honour will also have had plenty of experience of what I would characterise as persistent abuse of that jurisdiction by litigants. But Your Honour may not have come across quite as egregious an example as the one that we see here today. I don't know whether Your Honour has had a chance to read the written submission.
Yes, Mr. Montague Smith and Ms. O'Sullivan and Mr. Shaheen, you can assume that I've read all the materials that are relevant to this application, and I've read some of the materials relating to the hearing on 30 June and 1 July of last year. And so I'm familiar with the way in which that unfolded. And somewhat unsatisfactory way in which it unfolded. I guess the issue that no doubt you'll address is whether that adjectival description of things as egregious really helps me when I come to apply the decree, because the decree has an operation of its own. And one thing, just while I'm interrupting you, Mr. Montague-Smith, which I apologise, what would help me is I don't have a clear picture of the position of each of the defendants in the onshore Dubai proceedings and what has happened in relation to those defendants in the onshore proceedings. So at some point, if you could clarify that for me, that would be helpful.
Yes, certainly. So if I can deal with that, the position of the defendants in these proceedings, well, perhaps it's best if I just sketch the background a little bit.
Yes.
I won't labour it because you've read it, but just to make sure that you have the facts fixed, and then I'll come to the Dubai court proceedings. Sorry, but just as to your question, how does the conduct affect your interpretation of the decree? It doesn't. Yes. But what is said against me is that that's not the only question that Your Honour has to consider when deciding whether to lift the stay. And it said, well, there's a degree of discretion involved in that. And when one comes to that question of discretion, if one gets there, then clearly the way in which this all came about is relevant. And the way in which this all came about is also plainly, we say, relevant to the subsequent question of the anti-suit. Yes. But just to let me just sketch the background, if I may, and no doubt if I'm labouring it, Your Honour can let me know. But it might give a bit of helpful context. So this all arises out of a loan agreement for $300 million, which was advanced by the claimants, who are a syndicate of banks. And the case, very simply, is that they want those loans back, and that the loans have been accelerated for various reasons. Now, amongst those reasons, they are that the loan money which was provided was misapplied, that the financial status of the business was misrepresented. There are effectively two sets of accounts, we say, that were being run, and that interest has not been serviced on the loans. The money was claimed in part on a proprietary basis, on the basis of the misapplication of the funds, and there was a claim for orders requiring perfection of a certain security that hadn't yet been perfected. So the money was advanced to the first defendant. The second defendant, who we've been calling Mr. Kbbo, is the chairman of the first defendant, and he's also the ultimate beneficial owner. And you will see his signature signing on behalf of many of the other defendants in these proceedings. Now, it was understood that the 5th to 19th defendants were all part of what was called the Kbbo Cpg group, the consumer products group, of which the first defendant was a major part. But in relation to some of the defendants, that's disputed. The fourth defendant is called Infinite, and that's a jointly owned investment vehicle owned by two individuals. That's Mr. Kbbo, second defendant, and also Mr. Kbbo. And can I just ask that everybody who's not speaking just go on mute, please? I think the Hadef and partners might be off mute. So what happened, we say, was that the loan was advanced to the first defendant, and the second to the 19th defendants all guaranteed borrowing in various ways. The 5th to 19th defendants did that in the lending agreement, in the lending agreements themselves, and so it appears in the conventional facilities agreement and also in the Murabha investment agency agreement. I don't need to show you that today. But Mr. Binbouti, D2, Mr. Kbbo, D3, and Infinite, D4, they all gave standalone guarantees. And all of those agreements, all of them, including the guarantees, including the underlying financing agreements, contained, firstly, an arbitration agreement, but the arbitration agreement was asymmetric, and so the syndicate was permitted to elect for court jurisdiction instead, in which case this court has exclusive jurisdiction. There's no dispute about that. I can show you the agreement in due course if you'd like to see it. So what has happened is that in these proceedings, only D3 and D18 have disputed jurisdiction, and Mr. Kbbo, that's D3, has said that his signature on the standalone guarantee was a forgery. The other party, D18, Spectrami, who supports this application, has claimed that when Mr. Binbouti purported to sign on its behalf. He had no authority to do so. And there were various corporate documents.
Sure that's the right number?
Sorry, can I ask again that the Hadef and Partners go on?
But you don't have to put the double 4, right? It's 1 4.
Hadef and Partners, could you go on mute, please?
4 2 7 3 1 0.
Hadef and Partners, please, can you go on mute?
Go on mute. You're interrupting our hearing.
Thank you. We've lost my learned friend, Ms. O'Sullivan, I'm afraid.
That was careless of us.
But, I mean, we've had a few people, I'm afraid, have been booted out, unfortunately.
You're right. It says Mr. Boer. I'm the only one now left from our side because I see that Miss O'Sullivan has left as well. Oh, she's rejoined, I think. Okay. I apologise.
I can't see Ms. O'Sullivan. But are you there, Ms. O'Sullivan?
Yes, my lord. My apologies. Fat fingers.
No, these things will happen. Mr. Montague-Smith, back to you.
Thank you. So that was the position that there were allegations of forgery of one sort or another levelled by the third defendant and the 18th defendant, and therefore they disputed jurisdiction. The rest of the Hadef defendants, so I'm going to call the Hadef defendants, if I may, going forward. So I'll tell you if I'm referring to the third defendant, otherwise it's going to take a very long time. They initially indicated an intention to dispute jurisdiction, but then they filed an acknowledgement of service indicating an intention to defend. Thank
you. All right. Well, I think we will press on, Mr. Montague-Smith, if that's okay. But while we're interrupted, could I just ask what happened to the objections to jurisdiction brought on behalf of Ds 3 and 18? They were just pending at the time the stay was granted, weren't they?
Just pending, yes. No application had yet been made, as I believe.
Well, applications from the files, I think applications were made in each case, but hadn't been heard.
You may be right, but I hadn't.
I think D18. I looked at this yesterday. D18 lodged an application because I've got 14 days, and both lodged within the 14-day period, I think.
Oh yes, no, there's no issue as to that. I wasn't sure whether the stay had come in before the period had expired, but I'm told that there are applications. Yes, that's correct.
Yeah, and they were just sitting there while the other matters went on for hearing on the 30th of June and the 1st of July.
That's correct. That's correct. Yeah. So the sequence in the DIFC court worked like this. So the claims started with a freezing order and various related orders, and they included the usual information orders to provide information about assets, but they also required the provision of tracing information, what had happened to the loan monies, because misapplication was central and there was a proprietary claim. And so the Hadef defendants initially produced a spreadsheet which showed, we say, widespread misapplication of the loans. Now, it was subsequently said by them that information hadn't been checked, and so it might or might not be correct. But as I say, they then, having indicated intention to dispute jurisdiction, they subsequently accepted jurisdiction, and they have never challenged the documents in the way that Mr. Al-Kbbo has, and all of them were signed by Mr. Bimbuti.
And what happened to the freezing and information orders? Are they still in existence? Are they still in force?
Yes. So the freezing order. So when the stay was imposed, going from past experience, the judge was clear, and he made it clear in the order that the freezing order continued.
That order was made against which defendant? Was that made against all defendants?
It was made against all but the third defendant, I think. So you've got it at bundle F. The original freezing order is at F1. It starts.
Right. Thank you. I'll just pull that up.
And so you see paragraph 1 on F3.
Yes.
The first respondent, the second respondent, and then the companies listed as the fourth tonight.
So it's made against all except D3.
All except D3. Correct. Exactly.
Thank you.
And so there were various information orders in relation to that, and what happened was that eventually the defendants asserted, who were required to provide information, most of them in particular in relation to the tracing information. They said they've been advised that if they provided that information, it might incriminate them, and so they pleaded privilege against self-incrimination. So that's how it worked. So the time for compliance with those orders has already expired. So they're either in contempt or they can make out their privilege claim. So what happened then was, following the freezing order, there were various skirmishes, various cross applications, which led up to the hearing over 2 days on the 30th of June and the 1st of July. And there was a scheduling dispute in advance of that. And the defendants, that is the Hadef defendants, had applied for judgment on various parts of the claim. So in particular, they said that because the loan had been accelerated, the obligations to perfect security could not survive, and therefore the claim for an injunction in relation to that should be struck out. They also applied to strike out the whole of the claim on the basis that the banks had not been properly joined. Everyone except for the first claimant had not been properly joined, and that because the first claimant was an agent, it didn't have title to make the claim. So there was a claim to strike out the whole claim, or for a preliminary issue to be determined on it. And then they also applied for judgment on the proprietary claim. That claim had been put as a claim for arising under a quis close trust because of the obligations to apply the money in particular ways. So in response to the assertion that the loan had been accelerated, the claimants then applied for immediate judgment, and they did it against effectively the Hadef defendants, again excluding the third defendant. So what was being said was, look, if your case is that the loan has been accelerated, then give us the money back. Because the defendants had refused to comply with the information orders on the basis of privilege, the claimants also applied for declarations that there was no privilege. And so there was a scheduling dispute about which of these should be decided and when. And on paper, the judge decided that the claimant's immediate judgment application wouldn't be heard at the hearing on the 30th of June. It had to be heard later. He ordered, he said later, that the privilege issues would be heard. But then at the hearing, we say that the defendants effectively provided him with a fait accompli. They didn't show up prepared to deal with the privilege application. And at the start of the hearing, we had another battle about what should be heard when, and the judge said, in effect, that things had moved on and there would need to be more time to deal with that. So he said that that should be listed, and the words he used were as soon as may be. So that's on day one of the hearing. Now, while all of this was happening, the defendants were, the Hadef defendants were secretly preparing to torpedo the proceedings, because they had issued a claim in the Dubai courts on the 28th of June. Now, your question was, who's done what? This is all of the Hadef defendants. So Ds 1 to 4, 13, 14, 16, and 17. So, or the respondents to the anti-suit plus D3. And we are told, in my learned friend's skeleton argument for today, that there was a hearing in the Dubai courts on the 30th of June, which of course was the first day of the hearing in the DIFC courts. Now, on the 1st of June, July, on the second day of the hearing, that is, we were then told briefly in the morning that some sort of claim had been issued in the Dubai courts. And then halfway through the day, the Hadef defendants emailed the court saying that they had applied to the JJC and that the DIFC proceedings were now automatically stayed. So they provided that by email during the course of submissions. And so what happened was the judge adjourned the hearing briefly to consult with the registrar to see what should happen next. And then when he came back on the line, he said that he considered that he had no option but to stay the proceedings and described this all as an appalling abusive process. And we can look at what actually happened in due course. Now, Your Honours, so in the Dubai courts, the position that has been taken is that the third defendant says that the guarantee purporting to be signed by him is a forgery. And he says he's never seen the document before. The rest of the Hadith defendants say that they suspect the documents, but they don't make a positive allegation of forgery. And before Your Honour, the Hadith defendants, those ones, do not feel able to dispute the documents today.
All right. Now, so in the Dubai proceedings, the other parties are the banks.
Yes.
And who else? The other defendants also joined?
Correct, as defendants.
And is any relief sought against the other defendants?
Well, it's hard to know exactly. I think the relief that is sought is against the claimants, I believe, and it's for $300 million. The explanation is not given. But effectively, the relief that is sought is in the first case, the appointment of an expert to assess the documents and determine whether or not they are genuine. And then
is there a convenient statement? Is there a convenient document? I've seen a few documents. Which is the easiest document to look at to try and get a handle on what the claims are in Dubai courts?
So if Your Honour has bundle C,
yes,
behind tab 2, and I believe it should be page 534. I'm afraid there are two sets of numbering, one at the top and one at the bottom, and I'm working from the ones at the bottom.
534. I can't, doesn't seem to be going. Oh, well. Almost there. Well, oh, I see. Using the numbering at the bottom, right? Okay. Yes. Okay.
If Your Honour has that, you'll see that the plaintiffs are Mr. Al-Kbbo, who's D3.
Yeah.
And then you've got the rest of the Hadith defendants, D1, D2, D4, and then 13, 14, 16, 17.
Right. Yes.
So it doesn't include 19, but they say 19 doesn't exist. And then if you roll down, if you go down, you will see the defendants are the banks, and then the rest of the rest of the defendants in these proceedings. So starting from page 537, defendant 11 is the group of Fatima, and you'll see all the other defendants there.
Yes.
And then if you go down to page 541, at paragraph 2 in the middle, you'll see under the heading on the facts regarding the first plaintiff, that's D3, Mr. Al-Kbbo. Paragraph 2 summarizes it. The plaintiff of the aforementioned personal guarantee document, it was evident to him, and from the first moment, that the signature affixed thereon does not belong to him. So that's his case.
Yes.
So he alleges forgery. And then the rest of the plaintiffs, from 2nd to 8th, you'll see at page 542, and then records the allegation. But then if you scroll down to 543, starting from the 2nd line, it says, whereas the plaintiffs from the 2nd to 8th suspect the validity of the documents attributed to them, and whereas they don't have the original documents related to the loan, therefore all of the plaintiffs' request for obligating the defendants to submit the original loan documents, and then so on, and then they reserve their rights.
Yes.
And then most of this is to deal with D3's objection at 545 on the objection for forgery, which isn't actually made in relation to the rest of the Hadith defendants. And then you have the plea for relief starting at 547. but you'll see paragraph 2 on 548 to delegate the criminal laboratory to examine the bond of personal guarantee for the first plaintiff, that's D3, and then in relation to the other defendants to obligate the defendants from 1st to 10th, that's the banks, to submit the originals of the loan contracts and powers of attorney and so forth, and 4, to obligate all of the defendants jointly and severally to pay the plaintiffs as compensation, that's all of the plaintiffs, an amount of $295 million.
But that can't embrace the non-Hadith defendants, can it? Because that couldn't be intended. They couldn't be seeking relief against them, could it?
Well, not logically, no, but there's not an awful lot that's logical about any of this. So on its face, it says all of the defendants.
But you'd have to read that as being the bank defendants, presumably.
Presumably, that's what's meant.
Makes sense. Yeah.
Presumably. And then the second thing that's sought, as you'll see on page 549, is the appointment of a banking expert committee to carry out various tasks, including to look at the documents and specimen signatures and determine whether or not they are valid.
Yeah.
And that's it. That's the whole of the claim. So it's a very bare bones claim.
Yes, but it does seem, and Ms. O'Sullivan can correct this in due course if she wishes, but it does seem that no relief is sought against any of the defendants in the DIFC proceedings are in the Dubai onshore proceedings. The only relief sought is against the banks, it seems.
Well, you're not being corrected, so I'll
yes,
that's the direction. Thank you. All right. Now, in relation to this, then clearly, once the stay had been issued, everything went into abeyance, and we'll talk about the reasons why that is. But just to jump forward a bit, Your Honour's decision in the Lacan case was issued in April, but as Your Honour will know, it didn't become public immediately. I certainly heard about it in May. I believe that it was published at the end of April, but it's I'm not exactly sure of the date. The end of April was what was submitted by the Hadef defendants in one of their written documents in relation to these proceedings. But as I say, I certainly heard about it in May, but only when the court refused a stay in another case. Now, in mid-May, our evidence is that we were told by the clerk to the JJC that a decision in this case in the JJC was ready. It just needed to be signed by the Chief Justice of the Court of Cassation. And then on the 20th of June, we were told that the Dubai court would be issuing its judgment on the 28th of July of this year. Now, in early July, at least one decision was issued by the JJC in another case. So, but there was still no sign of our case. And so we appear to be back to the position where there's just simply an indefinite timescale on the JJC proceedings. So in light of those facts, and given that there was to be a judgment in July, the claimants made this application. So that's the context for these applications. In relation to the pure question of law, are there conditions for a stay under the Decree 19? It doesn't affect that. But it does, as I say, potentially affect questions of discretion and questions for the anti-suit. So just then dealing, if I may, with that question of law. Is there an obligation, the central question, do the conditions exist for a mandatory stay under Decree 19? And Your Honour will be very familiar, I believe, with the relevant provisions and the authorities on this point. But I may have to just take Your Honour back to the authorities, if I may, very briefly, just so I can make clear what my points are on these documents. Going back firstly then to Lacan itself, if Your Honour has bundle H.
Yes, I've got a hard copy of Lacan here. So
I'm grateful.
It's well thumbed.
What's that, sorry?
It's well thumbed.
Well thumbed, yes, quite. All right. Well, look, if we start at paragraph 22, we see the three different translations.
Yes.
And I've got that for those for others who are working from the bundles at page 8 H541. And so we've got three different translations. We've got determining what counts as a dispute. So firstly, under one of the translations, it's where both courts have claimed or disclaimed jurisdiction, or where the two courts have issued inconsistent decisions on jurisdiction. And the others are at paragraph 26 and 27. So we've got that then must be both courts. We've lost the judge.
Through Lacan. You're taking me to paragraph 22.
Thank you. Yeah. So I was just showing you the three different, reminding you of the three different translations.
There's another translation that I was given in another case, and that's the LexisNexis translation.
I see.
So
I haven't seen that.
There are at least four running around, right. I think.
All right. Right. Okay. So let me show you at least the one, remind you at least of the one in paragraph 27, which is the Westlaw one, because that's been commented on by Justice Cook in the Abrage case, and you may also have seen his comments in that. But the distinction there is, the test there is said to be that no court decides to waive hearing of the action, or both courts waive the hearing thereof, or enter contradicting judgments thereon. And what Justice Cook has said is that when you look at the word thereon, it's difficult to know whether that applies to a decision on jurisdiction or a decision on the merits.
Yeah.
And his point on that, if you go back up to paragraph 20, is that by reference to Article 1 of the decree,
yes,
it looks like that must be a decision on the merits, because Article 1 of the decree establishes its competencies and powers, so the reasons for it. And the question is, firstly, determining the competent court to hear a claim or application in respect of which there may arise a conflict as to whether the Dubai courts have jurisdiction, and secondly, determining the judgment that should be enforced in a case of conflicting judgments issued by the Dubai courts. So because it's talking, and the DIFC courts, so because it's talking about enforcement of judgments, Justice Cook says, well, thereon is most likely to mean a decision on the merits, and that then reinforces the point that Your Honour made at paragraph 33 of this decision, which we'll come on to in a moment, which was that if it's talking about inconsistent judgments, then it can't be right that simply... Sorry, again, could everyone else go on mute, please? Thank you. So if it contemplates inconsistent judgments on the merits, then when it talks about a conflict of jurisdiction, it can't be sufficient just to have two cases running in parallel, because otherwise there would be no point. You'd always immediately have a conflict of jurisdiction before you ever got anywhere near a judgment. So that was the wrinkle that Justice Cook smoothed out in the Abrage case, but we can have a quick look at that a little later on. So the argument...
Do you want to deal with that, Mr. Montague-Smith? Because I think it is pretty important to the resolution of this case, because if you take the position which Justice Cook seems to have taken, that there can only be a conflict of jurisdiction where both courts have expressly turned their mind to the question and both ruled on that question, then that gives a much narrower operation to the decree, and it would only mean to be satisfied in those circumstances. Now, Justice Cook seems to rely on the decision in Lacan for that proposition, and I myself can't see that in Lacan. I see exactly the opposite, where it was expressly left open. But so I think we need to tease through that, because I'm not presently, I should tell you clearly, I'm not presently persuaded by Abrage.
I see. All right. Well, let's go through this one then. So if we look at paragraph 33.
Yes.
So the argument was that simply having a claim in each court meant that there was waiver of jurisdiction. That was the
sorry, can I just stop you there? The question was, and I think it's important to bear the facts of Lacan in mind.
Yeah.
Because in Lacan, had happened was that proceedings had been commenced and an application was about to be heard in relation to an objection to jurisdiction. So the first thing that happened was there was an objection to jurisdiction lodged. Nothing else happened except the objection to jurisdiction came along, and then the proceedings into by courts were filed. So the question in Lacan was whether, in a case in which nothing else had happened other than an unresolved objection to jurisdiction, there could be said to be a conflict.
Yeah.
And I think you need to read Lacan with those facts fairly firmly in mind.
Yeah, no,
So that what the court in Lacan was saying was the mere commencement of proceedings can't be enough.
Yes.
There has to be some step taken by the court in the exercise of jurisdiction. And then on the question of whether a step taken in the exercise of jurisdiction was sufficient, the court left that expressly left that open.
Yeah.
So yeah, all right.
Yeah. So just taking it in stages, paragraph 33 is the point at which the court says, in the middle of the paragraph, maintaining or declining jurisdiction over a claim must be something less than judgment on the substance of the claim. Conversely, mere existence of proceedings with the same claim in both of the courts cannot be enough for a conflict of jurisdiction.
Yeah.
Right.
So that's making the point that the fact that you just lodging a claim doesn't give rise to a conflict.
Yeah, absolutely. Yeah. All right. And then over the page, just at the end of paragraph 34, you record the submission. Thus, it is submitted so long as the two cases were alive without ruling on jurisdiction, there was a conflict of jurisdiction. If that were correct, there would be a conflict of jurisdiction from the moment of commencement of proceedings with the same subject matter in both courts, with no need or occasion for reference to inconsistent judgments. So that's the conclusion. And then at the end of paragraph 35, the last sentence of that, Your Honour says, as no court decides to waive the hearing of the action, which had to be the nub of the claimant's submission as the negative act, it must be read with the alternative of waiving the hearing, indicating a choice. There must at least be an occasion for deciding to waive or not waive, as is clear from the other translations.
Now I think you just need to step back and work through 35, perhaps a little more, because 35 says the court doesn't do so, where a party commences proceedings, it asks the court to act. Court doesn't do so by the administrative act of receiving the process. There must be some step in the proceedings amounting to a relevant exercise of jurisdiction by the court or refusal of the step on jurisdictional grounds in order that there be maintenance or declining of jurisdiction within the words in the chapeau. All words require a positive act so that no court's claimed and so forth. And then as no court decides to hearing, that must be read with the alternative of waiving the hearing. There must be at least an occasion. Now, when you go back to the facts, the occasion, as I read that, and of course I was involved in one of those who wrote it, the occasion doesn't necessarily have to be an objection to jurisdiction. The occasion simply has to be the opportunity for engaging with a party in the process of resolving the dispute.
Well,
and that's consistent with all the other with the rest of the paragraph which precedes it.
Well, let me make this point. That is not how I read it, but Your Honour was obviously, as you say, on the panel, because what Your Honour asks for is a choice. Now, clearly, there are two different ways in which this court can make a choice as to whether it has jurisdiction. There can be an application before the court, which is then determined, and that is the opportunity for the court to make a choice. The court may also, of its own motion, decide that it needs to consider whether it has jurisdiction. That is, in principle, an available option, but in practice, it almost never occurs.
Now, you see, I think there's a third option, Mr. Montague-Smith, and that is that the court simply proceeds to exercise jurisdiction without considering the question of whether or not it has jurisdiction, which will be the ordinary case.
Well, I see.
And that is the occasion upon which the court has the alternative of waiving, but chooses not to.
But
so
does
in other
it
words, it doesn't necessarily mean there has to be a conscious turning of the mind. You see, if that's the way you read that, then the first sentence of paragraph 37 wouldn't make any sense.
Well, hang on. So if we just, I'll come to the first sentence of paragraph 37. I won't dodge that one.
Yeah.
But just, I think in terms of how I have read this, and certainly how Justice Cook has read this, it requires a choice. And the concept of a choice being made unconsciously is not known to me.
Well,
one has to make a conscious choice, a decision, a choice between two options.
But there has to be an occasion. That the choice is either to exercise jurisdiction or not exercise jurisdiction. The point being made in the last sentence there is that there has to be an occasion for that, which of course in Lacan there hadn't been. There'd been no occasion in Lacan for any engagement in the substance of the dispute. So I mean, the other point is whatever was said on that issue in Lacan would necessarily be obiter anyway. But there is, I think, a problem, as you appreciate, in relation to how you reconcile the construction which you would place upon paragraph 35 with the first paragraph of 37.
So in 37,
the first sentence of 37.
Expressly, we're not deciding the issue of whether or not it's sufficient for the court to exercise jurisdiction towards determining the claim. And I agree that there's a tension between that and suggesting that the ratio of Lacan is that you have to have a positive choice. But
well, that can't be the ratio of Lacan because there was no occasion. There was no occasion for positive choice.
Well, it could be in the sense that Lacan could be construing the statute and saying this is the test. The test is not satisfied in this case. Now, it might be right that a different test would also have been satisfied, but it would still be right that if that was what that sentence meant, if that paragraph meant, that would be the ratio of Lacan.
Well, if that's right, then the decree will, given the practice of the Dubai courts, which is to I haven't yet seen a case in which the Dubai courts have decided jurisdiction as a preliminary issue.
It does happen.
Well, okay, well, it does happen, but infrequently. But if you need a decision on jurisdiction, specific decision on jurisdiction in both courts for there to be a conflict, then it will very seldom occur.
But that is the way that the Dubai courts appear now to be approaching the matter. So they are proceeding with matters, and this case is an example, despite J.J.C. applications where you have two competing claims for effectively the same relief, or mirror relief. That is the way that the Dubai courts are approaching it. They are not staying proceedings in light of the J.J.C. So the other point that I would make is that Your Honour's judgment goes on to say at paragraph 36, this makes good sense, because since otherwise there would be an opportunity for abuse by commencing proceedings without a jurisdictional basis and thereby applying without
that's in a Lacan circumstance in which there had been no step taken by the DIFC court.
But my point is that if Your Honour is going to, if I can put it this way, retreat to a different interpretation or a lesser interpretation of what's required, then the abuse will be in every case. So Your Honour's point is that, well,
no, it won't. It will only be in a case in which both courts are proceeding with the positive exercise of jurisdiction, and that is consistent, I think, with all of paragraph 35 except the last sentence. Well, and it's a possibility that is expressed. It's not a retreat because it's a possibility that it's expressly left open by paragraph 37. That is a situation in which both courts embark upon the exercise of jurisdiction without expressly saying we have turned our minds to jurisdiction and decided that we have it. The de facto exercise of jurisdiction is sufficient to give rise to a conflict. And it's hard to see why that wouldn't be the proper interpretation of the decree when you look at the vice that the decree self-evidently, I think, is aimed at is the avoidance of the risk of inconsistent decisions and the avoidance of the burden of multiplicity of proceedings on parties. Now, those vices will both occur wherever the two courts are simultaneously exercising jurisdiction over the same dispute, irrespective of whether or not they've turned their minds to the question of whether or not they have jurisdiction. That is to say, irrespective of whether somebody has objected and they've ruled on it, the policy objectives that appear to underpin the decree are diminished if both courts proceed to exercise jurisdiction simultaneously, aren't they?
Well, that is clearly one of the factors, the avoidance of multiplicity of proceedings, one of the factors that Your Honour will be concerned to protect in interpreting this statute. But it's not the only factor out there. And what I had understood Your Honour was saying in paragraph 36 at the beginning was you have to interpret this statute in a way, or this decree, in a way which doesn't just simply give license to abusive conduct. Now,
yes, and that's, again, I'm sorry for interrupting, and I will try and bide my tongue a little more, but the point being made is that I think, and the way I read that paragraph, is that there has to be some action on the part of the courts that gives rise to the conflict of jurisdiction. You can't leave the matter entirely in the hands of the parties. So in other words, the first sentence of 36 says there would be clear abuse because you could just commence proceedings, the court does nothing in response to those proceedings, you go to the JJT and you get a stay. And that's what was happening. That's what happened in Lacan. And that's what happened in this case too.
Yeah.
So the point being made is that there has to be something more than that to avoid abuse. And the question is, what more is required?
Yeah.
You say, and Justice Cook has said in Abrage, that the thing more has to be a positive determination on the question of jurisdiction by both courts. The contrary view, I think quite explicitly left open in Lacan, is whether it is sufficient that both courts simultaneously exercise jurisdiction over the same dispute by engaging with the parties in relation to the substantive determination of the dispute or some other manifestation of the exercise of jurisdiction, thus giving rise to the vices, the two vices that the decree seems to be aimed at avoiding, that is, the risk of inconsistent or contradictory judgments and the burden on the parties of the multiplicity of proceedings. And those two vices don't depend upon a specific determination by the courts as to jurisdiction. It's sufficient if both courts simultaneously exercise jurisdiction.
But the point I'm trying to get across, and I'm not doing a very good job at it, I imagine, is that if that is all that is required, some step towards determining the merits, some direction, for example, for the filing of evidence, if that is everything that is required, then your point, if it's right, the Dubai courts never, or very seldom, or very determine jurisdiction as a preliminary issue, or at least the Dubai courts very often go ahead and put jurisdiction together with the merits, means that this policy will never be in any way respected.
Well, it will, because if a party wishes to assert that the DIFC court doesn't have jurisdiction, then they make that assertion at the appropriate time. That is, when filing the acknowledgement of service followed up by an application. If they don't take that step, then there will be no occasion for the court to consider its own jurisdiction, and it will proceed to exercise it. So if a party doesn't take that step, or if a party takes that step in the Dubai courts and the Dubai courts just ignore it and proceed on with the case, then the vice of the decree occurs. But you can protect yourself against that by taking the step that was taken in Lacan, and which two of the defendants in this case have taken, by objecting to the jurisdiction of the DIFC courts. And then it's only if there is a conscious decision by the DIFC courts they have jurisdiction that you've got a conflict. But on the other hand, if you're a defendant in these DIFC courts and you don't object, and the court goes on and exercises jurisdiction, and the court in Dubai is also exercising jurisdiction in respect of those defendants, then it's hard for me to see why the conditions for the operation of the decree aren't met. And part of that problem, I think, is that there is, in both Justice Cook's decision and in the paragraph, in paragraph 35 of Lacan, there's reliance upon the translation that refers to waiving the hearing. And that form of words does connote a positive decision about jurisdiction. But if you go to the other interpretations, they don't have the same notion. So if you go to the Wilberforce Chambers translation, that refers to both courts had claimed or disclaimed jurisdiction. or if you go to the Supreme Legislative Committee translation, it's both of them assert or decline jurisdiction.
Yes.
And then in the LexisNexis, it is as none of the courts has gave up hearing of the case, or all of the courts have given up same.
So your Honour's given me quite a lot of points to deal with in a.
Yes, all right. Well, I'll do my best to be quiet for a while, Mr. Montague-Smith.
I'm not asking you to do that, Your Honour, but Your Honour's making a lot of different points,
Yeah.
and there are answers to each of those points, and I'm trying to take a note of each one and answer them as they come up. But
yes.
Your Honour says, well, you can protect yourself. So just coming back to where we started.
Yes.
If there is a policy of interpreting this piece of legislation in a way which discourages or at least does not reward abuse, then that policy is totally disregarded by this approach, because what Your Honour has said is that you can protect yourself from a conflict of jurisdiction by disputing jurisdiction in the DIFC courts, and then until the DIFC courts determine that, well, then there can be no dispute of jurisdiction. So the difficulty there, of course, is if you're the claimant, because what that is therefore saying is that a defendant who genuinely disputes jurisdiction of the DIFC courts and therefore genuinely, on solid reasons, decides that this is a dispute which belongs in the Dubai courts and that there shouldn't be anything to prevent them from bringing that claim in the Dubai courts, is not going to get to a conflict of jurisdiction. But a defendant who takes a wholly abusive approach to it all and says, I'm going to submit to the DIFC courts. I don't dispute that there's an exclusive jurisdiction agreement in favour of the DIFC courts. In fact, what I'm going to do, as happened in this case, is I'm going to apply for judgment in this case and lose, and then I'm going to go off to the Dubai courts and the JJC, is in a better position, because on Your Honour's analysis, there is an automatic conflict of jurisdiction. So if there is any value in the policy of not rewarding abuse, this gets it upside down, because this rewards the more abusive the conduct.
Well, only because the Dubai courts don't deal with challenges to jurisdiction. So in other words, if the Dubai courts adopted the approach which this court takes, by immediately determining a challenge to jurisdiction, then claimants in the situation your clients find themselves in, who challenge, and I assume they've challenged the jurisdiction in the Dubai courts, haven't they? And so if that challenge had been determined, then the problem to which you refer wouldn't arise. Now, the problem is we can't tell the Dubai courts what to do.
Right, but the Dubai courts are part of the system which this decree is intended to regulate, and that practice of the Dubai courts is one that's known throughout at the time of the issue of the decree. And so if Your Honour is trying to understand what is the intention of this decree, is the intention genuinely to say that a party can engineer a stay by more abusive conduct than that they can engineer a stay by simply taking the ordinary approach and contesting genuinely jurisdiction. So that is why we say that it must be right that you need a positive decision on jurisdiction to trigger a stay, because otherwise you have a situation like the one we have here, where you have just a party behaving as they please, using utterly abusive conduct to engineer a stay, in circumstances, if they played by the rules, then they wouldn't have got their stay. So actually, if Your Honour's decision is to be, well, in circumstances such as this, I'm afraid there is a stay, well, then Your Honour is simply inviting this sort of conduct, in fact, endorsing this sort of conduct. And Your Honour will know how significant a problem this is for the jurisdiction. Now, one might say, well, all right, that's a matter of, that's what the decree does, that we have to live with it, and we all have to go along with it. But what I would anticipate is that when interpreting that piece of legislation, the judiciary would interpret it in a way which makes the system work, not one which actually introduces a circuit breaker for defendants who want to behave as they please. And that is what Your Honour will be doing if Your Honour says, no, that this is just I'm afraid, how it goes. So there is an interpretation open to Your Honour, which would lead to a solution which makes the system as it currently operates, with the Dubai courts merrily carrying on with cases regardless, and which requires that there be conflicting decisions on jurisdiction. That would make the system work. At the moment, the system doesn't work.
The contrary argument, Mr. Montague-Smith, and I'll let you go back to the other points that I raised with you in a minute. The contrary argument is that the construction for which you now contend means the decree would never work, because if conscious decisions with respect to the existence of jurisdiction are required by both courts, and if it is a notorious fact that the Dubai court seldom makes such decisions until the substantive determination of the merits, then there would be little or very, very few occasions upon which both courts would have made decisions with respect to jurisdiction such that the decree would operate.
But that would be in the hands of the Dubai courts. It would be open to the Dubai courts to take an approach which did that. The alternative interpretation, and this is precisely the point that I thought Your Honour was getting at in the Lacan judgment, is the alternative interpretation places that power in the hands of the parties, because the parties, all they have to do to get their stay is they just have to not contest jurisdiction in the DIFC courts and then go ahead in the Dubai courts, and all of a sudden the Dubai courts, you have your conflict. And so the point here is, starkly, do you want this system to work or not? And ultimately it doesn't work. You've got a situation where you've got a court system that is established to keep parties to their bargains and therefore attract external investment. At the moment, the DIFC court's interpretation prior to Lacan of this piece of legislation just hands over the DIFC court's power to protect its own jurisdiction to some other people. And not only that, it's being applied inconsistently between the two court systems, such that the DIFC courts have simply, on this interpretation, would simply, in effect, be washing their hands of these sorts of disputes and saying, there's nothing much we can do. Yes, the Dubai courts are carrying on with it, but I'm afraid, we're going to be very proper about this, and this is what it needs. Now, if you take that approach, then we're stuck with a situation, as we have in this case, where parties with very serious, very significant claims to which no defence has ever been advanced can turn up to court and say, I don't dispute that there's a jurisdiction agreement for the purposes of today. I don't explain why I've gone off to the Dubai courts, but you should, that's just, I'm going to be allowed to do this, and that's the way the system is designed. One has to take a step back from this sort of legislation and see how it operates, and see whether or not that is this really what that piece of legislation is intended to achieve? Is that genuinely the way the system is intended to operate? If Your Honour feels that it is, well, we'll have to live with that. But one has to see the damage that will do to this jurisdiction. I'm afraid it's substantial.
Well, I understand the policy issue, and I understand the impact on the jurisdiction. But isn't there another point, and that is that what we're talking about is a matter that goes to the jurisdiction of the JJT as well. So that if, and again, just entering into the field of policy, if this court takes the view that the jurisdiction of the JJT depends upon a conflict in the sense of both courts having turned their mind to jurisdiction and having decided to exercise it, or both having turned their mind to it and decided not to exercise it, then the capacity for the JJT to intervene and make orders stopping inconsistency is very much diminished, isn't it? Let me ask you to hypothesize a JJT operating in accordance with the decree and making decisions within 30 days of application to it. In that hypothesis, a broader approach to the jurisdiction of the JJT would be more effective than the narrow approach for which you're now contending, wouldn't it?
Well, not necessarily. It just depends. So the point that Your Honour's making is, well, if there's a 30-day, because there's a 30.
What I'm making is that the problem has arisen because the JJT is very, very slow in making its decision.
It's not the only problem, Your Honour. It's not the only problem. The problem that arises is that the introduction of the JJT fundamentally undermines the independence of this court. So the purpose of introducing this court is to have an independent body of decision makers deciding independently, with judges such as yourself coming in from international, because you have respected, incorruptible reputations. And it's not a question of comparing this court to the DIFC court. It's a question of advertising the DIFC to the international community, because they know if they come to this court, if they, for example, if they are a syndicate of international banks and they agree to this court's jurisdiction, then that allows them the confidence to invest in the jurisdiction, because they know ultimately their disputes will come before a panel of international judges. Now, if you have a system which just pulls the entire rug out from underneath that, then you undermine the very policy basis on which the jurisdiction is established. So is it such a bad thing if that piece of legislation is interpreted in a narrow way, just regardless of the problems that we have with the actual practicalities of the JJT? No, it's not. Of course it's not. It's consistent with the independent establishment of this court and the whole, which is the bedrock of the entire jurisdiction, the whole of the DIFC, that sort of thing should only happen in extreme circumstances. Now, coming back to the interpretation point, though, how can this interpretation give any effect to the purpose of the decree, which is recorded in paragraph 1, article 1 of the decree? So if we go back to the paragraph 20, and this was Justice Cook's point. If the answer is paragraph 20, subsection 2, you'll see that recites article 1. Part of the competencies and powers is determining the judgment that should be enforced in the case of conflicting judgments by the Dubai courts and the DIFC courts in relation to the same parties and the same subject matter. So it is contemplated that there will be, in certain cases, conflicting judgments on the merits, and a decision will need to be made as to which one will be enforced. Now, the only way you can get there is if there is no conflict of jurisdiction, or could be, in principle, no conflict of jurisdiction, up to the point of merits judgments. So if your honest, tentative view was correct, that some sort of exercise of jurisdiction, and we haven't quite got to the point of what that might entail, but say, for example, directions for the filing of submissions on the merits, something like that, amounted to a conflict of jurisdiction, you're never going to get to conflicting decisions on the substance.
Well, in this case, of course, it's gone rather further. Your clients have obtained injunctive relief against all the defendants.
Yes.
So if an exercise of, it's hard to see that wouldn't amount to the exercise of jurisdiction, isn't it?
Well, it depends what one means by that. It's certainly exercise of the powers, Your Honour. But the question of whether or not the court has jurisdiction isn't, one can get an injunction even when there's a jurisdiction dispute. I'm not suggesting that this court hasn't on, it's determined, at the defendant's invitation, it's determined issues in the dispute on the merits. I'm not suggesting that it hasn't done that. It has done that. There is a merits judgment from this court. The question is it sufficient that there's simply a live case in the Dubai courts in relation to which the parties have filed certain submissions, and the case has been listed for judgment, and there's been various directions. So my clients have been ordered to file powers of attorney. They've been ordered to file the originals of D3's guarantee, which they have done, and they've been ordered to file the originals of all of the other banking documents, which they have not done. They've asked for directions on that. So the question is that sufficient to amount to a dispute, to assertion or acceptance or non-waiver of jurisdiction? Just as a matter of language, that's very difficult in circumstances where my client disputes jurisdiction and the dispute of jurisdiction has not been determined yet. So it's been listed for judgment. We don't know what that means. It might be a judgment of jurisdiction.
It's really quite. I think it comes down, in this case, to a quite simple proposition, and that is that if a conflict in jurisdiction, such as to enliven the jurisdiction of the JJT, arises in a circumstance in which both courts positively exercise jurisdiction with respect to the substantive determination of the dispute, then in this case both have.
But
at least in respect of the Hadith defendants. But just hear me out. But if, as Justice Cook seems to have held in a barrage, if a conflict of jurisdiction only arises when both courts consciously turn their mind to the question of jurisdiction and both rule that they have jurisdiction, then in this case neither has. So there is no conflict of jurisdiction. So it seems to me that the resolution of this case, at least in respect of the defendants who are active participants in the Dubai proceedings, and that may be a different position in relation to the other defendants, but at least in relation to the Hadith defendants, leaving aside D3, to whom different considerations apply, but at least in the case of the Hadith defendants, the claim against them stands or falls on this question of interpretation, namely whether there has to be a specific decision with respect to jurisdiction or whether it's sufficient that jurisdiction be exercised in fact.
I disagree with that. Yeah. What I'd say is clearly that question of interpretation is one issue. Does there need to be a positive decision on jurisdiction? I say there does. But even if there does not, there's then the further question of whether or not what has happened in the Dubai courts amounts to some sort of positive assertion of jurisdiction. Now, Your Honour seems to have concluded that it does, but it's very difficult to see how that can be the case when my client's jurisdiction dispute has not yet been determined, and so we do not know what the Dubai courts are going to decide at the end of the day on Wednesday.
But so, they have required you to engage on the merits, haven't they?
No, all they have required us to do is provide original copies of the documents. Now, those original copies of the documents go to the question of forgery and therefore to the question of jurisdiction. So the point we make in our written submissions is what's the difference between that and directions for evidence in a jurisdiction dispute in the D.F.C. cause? Would Your Honour say that was an exercise of the court's jurisdiction?
Yes. So, really, you're putting it 2 points. So just see if I've got this right. You're saying, firstly, as a matter of principle, while there is an unresolved objection to jurisdiction in the Dubai courts, they shouldn't be taken to be exercising jurisdiction.
Correct.
And secondly, in the circumstances of this case, when you look at what they've done, everything is potentially referable to steps taken toward the resolution of the objection to jurisdiction rather than the substantive determination of the dispute.
Correct.
Yes, all right.
So until they've decided jurisdiction, and it's not impossible they'll decide that together with the merits, who knows, but until they've decided jurisdiction, one can see in this court, for example, it's not impossible that a judge would say, well, look, I've got a jurisdiction dispute coming up, but I really need to understand what are the issues in the claim, because I need to resolve a question of forum non-convenience, for example. So I need to know what issues are going to arise in these proceedings, and therefore I want fully pleaded proceedings, for example. So even if you can construe them, which I don't think you can, as directing or requiring some submissions on the merits, that wouldn't be sufficient to say, that is the court engaging jurisdiction within the meaning of the decree. But in any event, what really has happened here is that my client has been directed only to provide evidence which, if received, would be relevant. It would be relevant, obviously, to both parts of the claim, both jurisdiction and the merits. But it can be explained as going primarily to the jurisdiction issues.
So just following this through, on your analysis of the decree, if nobody objected to jurisdiction in either court, so that no occasion for the consideration of jurisdiction ever arose, then the decree couldn't operate unless and until there were inconsistent judgments.
Correct.
Yes, all right.
So if you have a situation like the present, where one party doesn't dispute jurisdiction in one court, but it does in the other court, then those are the circumstances in which there are other mechanisms to control that situation, which is the second part of my application today.
Well,
but the existence of that jurisdiction is consistent with the JJC, but it would be inconsistent with the JJC if you took too broad a view of the question of what amounts to a conflict.
But are there cases, and I'm jumping ahead of ourselves, but are there cases in which one or other of the Dubai courts has, either the DIFC courts or the onshore courts, issued anti-suit injunctions in respect of proceedings in the other?
Yes, there are.
All right.
Yes, there are. I'm afraid we don't have a judgment, but there are. Bear with me. So there are 3 cases that I was going to take Your Honour to in relation to this issue. In one of those, an injunction was not issued. That was a case called Brookfield Multiplex. It's about an arbitration agreement which was construed as being in favour of the DIFC courts, and the question was whether or not the DIFC courts could restrain action that had been taken in the Dubai courts in light of that. And Justice Cook said yes, having regard to the deference that needs to be given to decisions of the local courts. That's a case called Brookfield Multiplex. In that case, no injunction was issued because the action that had been taken was action to appoint an expert, which wasn't inconsistent with the arbitration agreement. There's another case after that, also decided by Justice Cook, in a case called Hayri International, Hayri and Hazim. And that was concerned with proceedings in Pakistan, but the effect of the order was to cover Dubai court proceedings. So it illustrates the principle that the DIFC court can grant those sorts of injunctions. And then there is another decision, although we don't have the judgment, we have the order in the bundle, which is in a case called Lujan, which was decided by Justice Shamlan, in which he made an order specifically to restrain Dubai court proceedings brought in breach of a DIFC arbitration agreement. So there are cases in which this court has granted anti-suit injunctions to restrain proceedings in the Dubai court.
Well, I must say, we'll come to this if we have to, but I must say that all sounds very strange to a lawyer from a federal background, because the considerations of comity as between the Australian courts in the different jurisdictions are such that no Australian court would contemplate, I don't think, issuing an anti-suit injunction in relation to proceedings in another Australian court. There are other mechanisms for the resolution of those disputes. Well, and I would have thought it's at least strongly arguable that the decree, at least since the publication of the decree, that is the mechanism for resolution of disputes with respect to parallel jurisdiction of the courts. But anyway, let's just park that up. Let's just park that up for the moment.
Can I just answer that briefly? Can I just answer that briefly, very briefly? Which is that this is not an inter-federal dispute. This is about control.
It's intra-emirate.
Yeah, quite.
So much more.
No, because actually, look at the origins of the anti-suit. Where was the anti-suit designed? It was designed in the courts of equity in London. Why? To restrain proceedings in the common law courts. That's where it came from. That is the basic underpinning of all of the history of the anti-suit injunction. It's not about restraining foreign courts. It's about providing a further mechanism for one nation, one state, to ensure that you don't get this ridiculous situation where you have competing decisions. But the question then is whether, and the point about that is, and it fits with my submissions about the independence of the DIFC court, is that that is a remedy in the hands of the DIFC courts, which is intended to be, rather like the courts of equity, this independent body. So it all hangs together. If you take that interpretation of the J.J.C. decree, which is that actually it needs to be limited, and I say again, the Dubai courts are taking this approach, it appears. They are not staying their proceedings. In those circumstances, you have an incredibly lopsided approach to all of this. If the DIFC says no, the circumstances are such that we're going to stop, but the Dubai courts are going to carry on. That, in my submission, would be a remarkable giving up by this court of the independent powers that it has been entrusted with. So it comes back to, Your Honour has the power to do what we're asking you to do. There is a perfectly respectable interpretation. I can see that this decree could be interpreted in two different ways. And yes, the effect of it is to limit the circumstances in which the decree operates, but limit it in a sensible way, which says that if you're going to bring parallel proceedings, you at least need to assert in both courts that the court that you want to bring your proceedings in is the right one.
There might be a middle ground in there, in the sense that, and I've been assuming that, perhaps wrongly, that on the construction for which you're contending, there have to be two conscious decisions with respect to jurisdiction. But it would certainly be sufficient for your purposes in this case if you construed the decree, perhaps not going as that far, but at least as saying, at least while there is an unresolved question as to jurisdiction in one of the courts, the conditions in which the decree operates can't be said to have arisen.
We do say that, but I do say, as someone who's operated in this jurisdiction for most of my career now, Your Honour has an opportunity to fix this. And it is a serious problem. You hear it all around the world. Practitioners say, why would we bother coming to the DIFC court?
And that lesser alternative, the one that would fix it, wouldn't it? In other words, so if there was an unresolved objection as to jurisdiction, then that would go a long way to addressing the problem, wouldn't it?
It would go a long way to addressing the problem. I don't consider that it would fix it, but it would go a long way. And
but if you had a situation in which one court, there was no objection to jurisdiction in one court, so that it was merrily proceeding along in the exercise of its jurisdiction without objection, and then somebody ran off to another court with a view to then playing the JJT card or JJC card, because there seem to be different acronyms depending on who you talk to.
Yeah.
But then, so long as the respondent to that second set of proceedings objected to jurisdiction, then as long as there was one unresolved objection to jurisdiction on foot, then there wouldn't be a stay.
Yes, yes.
Yes. Leaving open, perhaps for another day, the situation in which there are proceedings in both courts to which nobody has objected, and those courts are proceeding along merrily.
Yes, and one would consider that to be an unlikely and unusual circumstance. Yes. Which might be the circumstance which leads to conflicting judgments, which, you know, is one of the things that the decree is intended to deal with.
Yes. Yes, all right.
You want to?
Sorry, Mr. Montague-Smith, I distracted you, and I'm been very bad at that today, I'm afraid, even worse than usual. But there were some other translations of the decree. Do you want to deal with those? I mean, I'm not sure that they make a lot of difference, but if you want to deal with them, I'll give you the opportunity to do so. The way of the hearing one is the strongest, I think, in support of the proposition you're putting. There are others that are not quite so strong.
Yes, I think that I rely in particular, though, on Justice Cook's point about Article 1, which I've made a couple of times, which is that there must at least be scope for there to be conflicting judgments on the merits, and therefore, insofar as there are decisions to be made about whether or not the conflicting judgments have to be on the merits or on jurisdiction, then they strongly support the conflicting judgments on the merits.
But then wouldn't that? But then I'm not sure that that helps, because then wouldn't that lead into the proposition that if the courts are engaging with the exercise of jurisdiction on the merits, then the vice of the decree is enlivened?
No, because what it must indicate is that there needs to be some contemplation that you will get to a decision on the merits in both courts.
Right.
And that would never happen if...
While there is an unresolved objection to jurisdiction.
While there's an unresolved objection to jurisdiction, but once, if there's no objection to jurisdiction, then that could happen, unless...
What would happen if there's no objection to jurisdiction? Both courts would proceed to judgment.
Yeah, quite. But if the interpretation is that taking steps in the lead up to judgment amounts to a conflict of jurisdiction in both courts, then that is never going to happen. So that's why I say it helps the interpretation of what amounts to a conflict of jurisdiction. And that was the point that Justice Cook was making in Abraj.
Yes, all right.
Jon, I'm going to try and shorten the rest of my submissions, because I think we've dealt with that in a fair bit of. So if you just bear with me for one moment.
Yes.
I think that's all I wanted to say in relation to the Lacan point, if I can put it like that. You've read Abraj, you've seen what's said in that.
Yes.
I won't take you back to that.
Yes.
But the Hadith defendants obviously say that we need to show a material change of circumstances in order to justify an application to lift the stay. I don't know whether you want to hear me on that first.
I've read your helpful submissions on that subject, Mr. Montague-Smith, and perhaps the most efficient course might be to hear what the other parties say in relation to that, and then give you a right to respond if there's anything unexpected.
Thank you, Your Honour. In which case, I think I can leave it there on the question of lifting the stay. And clearly it makes sense for you to hear what my learned friends have to say on the stay before we deal with the second application.
Yes, I agree. I agree with that. Ms. O'Sullivan, would you like to go next?
Yeah, thank you, my lord. Before I begin on substantive submissions, my lord, may I just correct a point? My learned friend referred to there being a hearing in the Dubai onshore court on the 30th of June. Now, that's in my skeleton, but I took that from paragraph 55 of Miss Davis's witness statement. And if for future reference, that is page C11. Now, I understand that's not correct. What there appears, I'm instructed, to have been an internal case management hearing, that there was not a hearing in the Dubai court on the 30th of June. So, my lord, turning to the issues, I mean, your lordship is very familiar with the issues, and particularly with the Lacan case. I was proposing to say very little, in addition to my written submissions, which you have. I propose principally to address points that you've been debating with my learned friend, which we did anticipate at paragraphs 9 to 13 of our skeleton of the 21st of July, in which, and we obviously do urge you to not to adopt the narrow construction of the decree which my learned friend urged upon you, requiring actual conflicting decisions or a conscious consideration of jurisdiction by both courts. That is the question. That's certainly not consistent with paragraph 37 of the judgment in Lacan, and we've prayed in aid the comments at paragraph 35, where the Court of Appeal, including yourself, referred to at least there must be some step in the proceedings amounting to a relevant exercise of jurisdiction by the court. Now, you, my lord, suggested there might be a third way, namely where both courts exercise jurisdiction without consciously considering whether or not they have jurisdiction. And we very much urge that upon you as something which is sufficient to track the application of the decree, and it's what's happened in this case. As you see from paragraph 12 of our submissions, we pointed out that both courts have actively taken steps. The courts, not the parties, the courts themselves have both taken active steps which are consistent with an exercise of jurisdiction over the merits. Now, my learned friend says his client's jurisdiction objection in the Dubai onshore court hasn't yet been resolved. It's difficult to tell that because, of course, in this case, and it won't be the only one of its nature, merits and jurisdiction are really the same point, in the sense that if the objection is that there is no binding agreement, that objection is also taken that there's no binding exclusive jurisdiction clause. So it's almost impossible, in a sense, to see how the court could decide that question as a preliminary issue without also deciding the merits. And we submit that the steps taken by the Dubai courts to date are equally consistent with them exercising jurisdiction of the merits. For example, ordering production of the originals of the documents. I mean, it could be said that they go to both, but it's certainly not referable exclusively to a jurisdiction challenge. So we urge upon you the approach which I think you first had in mind, my lord, in terms of what's sufficient to attract the conditions for the operation of the decree. We say that's met on the facts here, because there has been a clear exercise of jurisdictional steps by both courts. Now, your lordship, sorry.
What has the Dubai court done?
It has
an exercise of jurisdiction.
It has ordered. It has ordered the exchange of memoranda, and it has ordered the production of the original documents. Now, I can see why my learned friend says, well, that's all consistent with the effective jurisdiction. But it's also consistent with an exercise of jurisdiction on the merits, simply because the issues are the same. The authenticity of the documents, and therefore whether they are binding upon the defendants, is what's in issue. I think we've set out, you'll find the chronology in Mrs. Witness statement, but we set out some of the material events in our on the anti-suit injunction from paragraph 9, where paragraphs 15 onwards, taking our material from Ms. Davis's statement, we have set out the various hearings which have taken place.
Yes.
So now, I mean, it's so. I wanted to come to your lordship's thoughts just recently that it might, that where you've got an unresolved jurisdiction complaint, which is what my learned friend says is happening in the Dubai court, whether that falls short of establishing the necessary conflict for the purposes of the decree and the reference to the J.J.C. and the stay. Now, again, the problem is in a case like this, where the steps taken by the courts are consistent, both with addressing the merits and the jurisdiction issue, because they are essentially one and the same issue. So, on your lordship's analysis, if that interpretation of the decree is adopted, then you would, in a case like this, where merits and substance are the same, merits and jurisdiction are the same, you wouldn't be able to refer that dispute to the JJC, because it would affect, because the Dubai court doesn't determine preliminary issues of jurisdiction, you'd have to wait until the merits judgment before going to the JJC and saying, please resolve this conflict. So, I can see it's a tempting route for your lordship to go down, but it does create real problems in a case like this, where you can't split the jurisdiction and merits issues.
Well, so what are those problems, Ms. O'Sullivan? Can you explain them to me?
Well, simply that if you're not, you won't in the Dubai courts get a determination on a definitive. So just to say, in other words, any jurisdiction objection will remain unresolved in such a case until the delivery of the merits judgment, by definition. So that would deprive the decree of any effect in cases like this, which are not uncommon.
Well, I know because I've heard 3 of them over the last 3 weeks. So.
Well, quite. But I mean, when I say cases like this, I mean cases in which the substance and the jurisdiction are bound up, so that you can't sever the jurisdiction issue and determine that as a preliminary issue. That's what creates the problem, and it's cases like that which are not uncommon. Because if the objection is, this is not my document, I didn't sign it, it was forged, it's not binding on me, then that is taken both to the objection is taken both to the main contract and to the jurisdiction agreement contained within it. So that would deprive the degree of effect in a case such as this. The other point I would make is really consistent with your lordship's observations on comity, which is that, I mean, this system would work perfectly well if the JJC issued its rulings more promptly. That is, I mean, the fact that it's dilatory in issuing its judgments is not something for which my client can be held responsible, and it's certainly not something that ought to affect the construction of the decree. A perfectly workable and sensible construction of the decree, which would give effect to its policy, is one that takes a broad view of what is necessary to trigger the reference to the JJC. It is the body that's tasked by statute with resolving these disputes. And I mean, I shall develop this point more when it comes to the anti-suit injunction, but there is a real risk, a real threat to judicial comity in the DIFC court being seen to arrogate to itself that decision, in effect by adopting a very narrow view in which the decree would not apply in many cases. So, subject to that, I mean, the only other point I was going to make on the lifting of the stay is a point which I'm sure your lordship is very much has in mind, which is, of course, the desirability of finality and certainty in litigation. And if the parties have acted for a year on the basis that there was a well understood practice, it's undesirable in principle to allow them to undo an order that was granted a year ago, simply because the Court of Appeal has taken a different view as the application of that practice. And potentially, I mean, as you said, your lordship is already dealing with 3, but you can see in any case in which case management orders are sought to be undone by reference to subsequent judgment creates problems in terms of finality and certainty. And so I urge you very much to bear that in mind when you're exercising your discretion.
Yes.
But subject to that, I wasn't preparing to go through my submissions in detail unless there's any point that you'd like specifically.
No, thank you, Ms. O'Sullivan. The written submission is very helpful, and I certainly understood all the points you're making.
Thank you.
Mr. Shaheen. Mr. Shaheen, do you wish to address us?
Am I audible?
Yes, you are now. Thank you.
Yes, Your Lordship. We are representing defendants 5 to 12.
Yes.
One of the main contentions that we have is we have not been afforded sufficient time, and we are challenging all those contentions raised by the claimants regarding the urgency of the matter. The stay order has been pending for more than a year, And even the judgment which they are citing in order to raise this issue of urgency was passed in April 2021. So all of a sudden to come on the previous day of the long Eid holidays and to make all of us work during the weekend and Eid holidays, especially when all our clients are Muslims and these are the most auspicious 10 days in the Islamic calendar in a year. It has been impossible for us to contact our clients and take instructions. As your Lordship knows, it's not me representing the clients before the Dubai court or the JJC. It's another law firm. We could not even contact them to see what exactly is the status of the proceedings there. And we have very serious contentions in the substantive claim. The only relationship I have in this is D2 holds shares in some of the companies, D5 to D12, nothing else.
Well, let me just stop you there, if I might, Mr. Shaheen.
Sure, Your Lordship.
Do I understand correctly that your clients are parties to the proceedings in Dubai, but no relief has been sought against them? Is that the correct understanding of the position?
Yes, they are made parties, D11 to D18, and they have made their submission before the JJC as well.
But they haven't. No relief has been sought against them, has it, in the Dubai proceedings?
No relief. I don't think that.
And they're not seeking relief, and no relief is sought against them.
The relief we would love to seek is to completely relieve us from the freezing orders. But just as Germany,
I'm talking about the Dubai proceedings.
No relief.
Your clients are not claimants in the Dubai proceedings, are they?
They are parties, but no relief is sought against them.
And they're not claimants, they're defendants, and no relief is sought against them.
Defendants 11 to 18, if I remember it right.
Yes. Well, how does any conflict of jurisdiction arise in relation to the Dubai proceedings and these proceedings, then, in relation to your clients?
Yes, because we are made parties in both the cases for no fault of us. And we are suffering because these companies are suffering from the freezing orders. We wanted a relief during the hearing in May 2020, but Honorable Justice rightly said that my hands are tied and I cannot do anything. There is a stay immediately, ipso facto.
Well, then, do you want the stay lifted?
We want the freezing orders to be lifted, not the stay.
Well, you can't have it both ways. If you want to lift the freezing orders, you've got to have the stay lifted so that you can apply to set them aside.
My difficulty is, Your Lordship, I have not been able to contact my clients because of the holidays in between to take instructions, and not been able to contact the concerned UAE national advocates who are representing them before the Dubai courts and the JJC. This is where I'm stuck. That is why my submissions, Your Lordship may see, are only on the urgency of the matter and on the technical aspects of the prayers made by the claimants before Your Lordship.
Well, I'll just ask you again, Mr. Shaheen, how can there be a conflict in jurisdiction between the case in the Dubai courts and the case in this court when no relief is sought against your clients in the Dubai courts?
It's not for me, Your Lordship, it's actually for the JJC to decide which is the proper forum where the case has to be decided. My humble plea is that it's beyond us, beyond the DIFC court's jurisdiction to pass such orders.
Well, your clients don't assert anything in the nature of forgery, do they?
Pardon me, Your Lordship?
Your clients do not assert that the documents to which they are said to be parties were forged, do they?
We do allege that some of those documents are forged. We are not, it's ultra virus to the objects of the companies.
I'm sorry, where have you made that allegation?
It is in the pleadings we presented during May 2020, and even in the oral hearing, that's page number E515. We have stated that.
E515, just a minute.
Open the E515. we have stated we are totally unaware of any document signed in our name. We are small entities with very limited capital. It's not within our objects to give guarantees and corporate guarantees for facilities like $200, $300 million, which is availed by somebody else, no relationship to us.
But you haven't alleged forgery, though. You haven't commenced proceedings alleging forgery of the documents.
Yes, we have mentioned it in one place, that suspected forgery, especially the subordination agreement, specifically.
Your Honour, it was said orally, if you look at page 520.
Yes.
520.
Unauthorised person, there was no shareholders resolution, etc. All right, 515, and then I'm looking at now 520, should I?
Your Honour, yes, about 2/3 of the way down the page. He did make an oral allegation. There's been no pleadings.
We also have a case of forgery to be made. One of the documents is forged. All right, thank you. All right, so you do allege.
At the time when I was making those submissions, some of the defendants were not even served. And after that, we are coming back today with such urgency where I have not been able to contact my clients and take specific instructions.
All right.
And my contention here is that it's beyond our jurisdiction, I mean Honorable DIFC Court's jurisdiction, to pass such orders which the claimants are requesting for. It's for the JJC to decide. What if the Dubai court decides otherwise? We don't want conflicting judgments here. We want a proper remedy. I want a proper relief, but my hands are tied is what His Lordship said at that moment. It's automatic stay, and we have been suffering. The businesses are almost completely ruined. And there are disputes ongoing between the Hadith defendants and defendants 5 to 12 before the Abu Dhabi court as well.
All right. Well,
receiver.
You say you're not in a position to deal with this application today. When would you be in a position to deal with it?
We need at least 1 week time. We can come up with proper instructions from our client and say exactly what is their position.
Yes, all right. Was there anything else you want to say, Mr. Shaheen?
It's only the technical aspects, Your Lordship. It's outside the jurisdiction of the Honorable Court to pass such anti-suit injection and also to lift the stay order when JJC has imposed a stay order as per Article 4 of the JJC law. And the urgency alleged is incorrect, and we need time, sufficient time to contact our clients and make proper submissions before the Honorable Court. I'm not asking for a month, I'm only asking for a week.
Right.
Thank you very much, Your Lordship, for this.
Yes, thank you, Mr. Shaheen. Well, that's effectively an application for adjournment, Mr. Montague-Smith. What do you say to it?
Well, there's the short question of construction of a statute, isn't there? I mean, ultimately, you know, lawyers have to work on weekends sometimes. It's just what we do. One doesn't need to take instructions. I have to say, I don't understand. I can see that my learned friend might need to take instructions to decide whether or not to oppose the application. But given that he is complaining that there is a freezing order and wants that set aside, I would have thought that he would be firmly in support of the application. It's rather odd. I do also say, which Your Honour might not be aware of, that my learned friend's clients have submitted to the jurisdiction. They filed acknowledgements of service indicating an intention to defend. So should my learned friend be in a position to give you submissions on Decree 19? Yes. It's a short point of law. He ought to be able to do. The application was made 11 days ago, and the application to adjourn is made in the middle of the hearing. I mean, in a sense, it doesn't matter so much the timing of this one, because what matters really is, from my perspective, is that Your Honour decides the point, at least insofar as the Hadith defendants are concerned, because I want to go on, obviously, and make my second application against them. And I don't have a second application against Goodwin's clients, but the issues will be the same. So it would be artificial to adjourn that off and not adjourn the rest off. And we've argued it fully. Your Honour's on top of it. So I would oppose any adjournment.
Yes, all right, I understand that. Mr. Shaheen, is there anything you want to say in response to that?
Lordship, if we are given sufficient time, we'll come back with clear instructions from our client and make a proper submission.
All right, thank you. Well, that raises the question now about where we go from here, and in particular whether we go on with the application for the anti-suit injunction, because clearly that only has utility if the stay is lifted, and really I could only make any orders if the stay is lifted. And I mean, I haven't come to a view on that question as yet. And as I mentioned, this is the third of these cases that I've heard. They all have different facts and circumstances. They all raise different issues. But obviously, and because of the importance of these issues, it's important that, well, at the very least, that my decisions in those three cases are internally consistent, which is an issue that's occupying my mind at the moment because I've had different arguments in different cases. And also, of course, given the importance of these issues and the sums involved, this is not the only case in which there's 300 million involved. There's another one in the same order of magnitude. The prospect of an appeal is very, very high, I would think. So I guess that then takes me on to the question of whether there is in truth an urgency in the application for the anti-suit injunction, Mr. Montague-Smith. The urgency is pressed on the basis there is a decision coming down on Wednesday.
Correct.
But we don't know what it is.
No, we don't.
But you would want me to... The hearing the anti-suit injunction would only be of utility if between now and Wednesday I issued orders of a mandatory kind, effectively requiring the Hadith parties to discontinue the Dubai proceedings.
Well, so there is a question as to whether or not we need mandatory relief. We say there is a strong prospect that we do need mandatory relief. That's not to say that I'm sitting here telling you that prohibitory relief would certainly be of no use at all. Prohibitory relief not to pursue the proceedings. So I do ask for that in the alternative.
But there's nothing to be done between, if your fear is Wednesday, and that's what's given rise to the urgency.
Correct.
There's nothing for the Hadith parties to do between now and Wednesday. So if they're prohibited, they just do nothing, that the judgment will come down.
Yes, correct in terms of Wednesday. As you say, though, we don't know what we're going to get on Wednesday. And it may be decisions going forward. The decision may be to appoint an expert or something of that nature. So a prohibitory order would have effect or have benefits after that time as well, potentially in that circumstance. So there are scenarios in which a prohibitory injunction would assist us going forward. Not for Wednesday, I agree. In terms of Wednesday, though, we need to know what the position is, because at some point my clients need to decide whether they're going to engage on the merits in those proceedings, and that point's going to come extremely swiftly. And do they just wait it out? What do they do? Do they take the risk and not put in anything on the merits? It's very difficult. So at this stage, we are asking Your Honour for an order, if possible, today. I understand the difficulty. I would just suggest, Your Honour says you haven't come to a view. I would hope that you've heard from the various different, and we obviously haven't been party to all of the other submissions, but you've heard pretty much everything there is to say on this issue. Our position is that the underlying policy issues are just very, very strong, and Your Honour should strain to make a decision that gives effect to them. But if Your Honour's not able to do that, Your Honour's not able to do that. But I'd urge you to try to reach a decision now. Of course, it's always possible for parties to appeal, but that's true of every case. And no doubt it will be done in this case too. So there genuinely is urgency, because it's already being said that we're taking conflicting positions in two different jurisdictions. That's not a fair allegation, particularly coming from the defendants in this case. But no doubt that will be said, that if the decision is made to defend on the merits, then that's the end of that. Is what will be said, and we may or may not ever get a decision out of the JJC. Who knows? Who knows what's going to happen there? So it's not just the fact of a judgment which You're right, we don't know what it will be. It's the activity that would need to be taken either way in the event that there is a decision of that sort this week.
Yeah, all right.
I mean, these sorts of decisions are taken in terms of the anti-suit. They are taken on an interim basis. If Your Honour sees that there is clear grounds, and normally an exclusive jurisdiction agreement would fit that, then a mandatory injunction would normally be issued. And we say that this is an even stronger case given the way that it all came about, because the purpose of the anti-suit is in part to stop parties from stealing a march, which is precisely what's happened in this case. It's not just the fact of the Dubai court proceedings, it's the concealment of those proceedings as well, which prevented us making this application back in June of last year. So you know, insofar as yeah, so there is real urgency, we say.
All right. What I think I should do, we've been going for 2 hours now. It's time for a break. What I think I should do is adjourn for 15 minutes. Is that long enough for everybody? Will that give you sufficient time for, still early in the morning there, so you probably just coffee or whatever. I'll adjourn for 15 minutes and just think about what to do. But I think I should probably hear, you're both here, you're ready to argue the anti-suit injunction. I think I should hear argument on that. And then I might have to reserve overnight to work out what I'm going to do, if anything. So what I'll do is I'll adjourn for 15 minutes. If I form some other view, I'll let you know. But otherwise, after 15 minutes, we'll proceed to hear the anti-suit injunction. All right. So we'll just adjourn for 15 minutes now. If you just turn cameras and microphones off, but leave the link on, that should all be fine.
Thank you.
Good.
Yes.
I think the 15 minutes has expired. So I have thought about it, and I think we should proceed as I indicated. That is that I should hear the parties that wish to address on the subject of the anti-suit injunction, and then consider what to do then. Mr. Shaheen, that doesn't involve you, so it's entirely up to you whether you wish to remain or leave. Well,
the message has been communicated.
Yes, okay. Mr. Shaheen, do you wish to remain for the hearing of the anti-suit application for anti-suit injunction?
Yes, Your Lordship. Although they don't seek any direct relief against my clients, we are parties to the ongoing litigation before Abu Dhabi court and Dubai court. And by any reason, if it is stretched, the application for anti-suit injunction against any of my clients, we will be put to serious hardship, because upon seeing the original documents, we may be inclined to even file a criminal case, because there are serious allegations, but we haven't got a chance to see the original documents.
All right. I was just giving you the opportunity to go and do something else if you wanted to. If you don't want to, that's fine. Mr. Montague-Smith.
Thank you, Your Honour. Just in terms of housekeeping very quickly, I'm told that the best prospect, if Your Honour was minded to grant an anti-suit requiring withdrawal of the claim, would be if that withdrawal was submitted tomorrow. I appreciate that accelerates the timescale. I know Your Honour's actually ahead, in fact, of Dubai, but if there was prospect of any kind of decision, at least by sort of open of business tomorrow, then that would be give us a better chance of making any order that you make effective. Obviously, that all anticipates the result, which I'm not doing, but sorry.
I asked you before, Mr. Montague-Smith, whether there are cases in which the anti-suit injunctions have been granted as between the Dubai courts, and you told me there were. But I raised this: is there any case in which such an injunction has been granted while an application is pending before the JJT?
I don't know the answer to that. I don't know.
That I have to say is one thing that is concerning me in relation to this, because of course one of the criteria for an anti-suit injunction is a high probability of success. I just wonder how.
I can't hear.
I'm sorry.
I'm awfully sorry to interrupt. I cannot hear or see the judge. If the judge is speaking,
I am.
I'm afraid I cannot hear or see him.
Zoe, can you hear me?
Yes.
Okay. So I can hear the judge. I can hear you.
I can neither see nor hear the judge.
I see.
Well, perhaps, Nathan, are you still there?
I can try. What I could try is logging in again.
Zoe, can you hear me?
I am going to log out and log back in and see if that fixes the problem.
All right. Okay, thank you.
Yes. Sorry about that, my lord. I can now hear you.
You can hear me as well?
I can, thank you.
Yes.
Sorry about that.
No, Mr. Montague-Smith, I was just saying the problem I'm having is if you go to the high probability of success, there is an unresolved claim of forgery in the Dubai courts. At least one of the defendants has objected to the jurisdiction of this court on the ground of forgery, and that objection hasn't been determined because of the stay. And there's an application before the JJT, which will result presumably in the JJT deciding which of the two courts should proceed to exercise jurisdiction. Just wondering how in those circumstances I could be satisfied that there's a high probability that this court will proceed to enforce the exclusive jurisdiction agreement.
So the application is not made against D3.
Right.
D3 is the only party who's positively asserted forgery and is a claimant to Dubai court proceedings. So I'm not asking you to resolve that issue.
Yes.
The respondents to this application are D1, D2, D4, D13, D14, D16 and D17. And their position in their skeleton argument is that they accept without conceding that there is sufficiently arguable case that the proceedings brought by them in the Dubai courts were brought in breach of the jurisdiction clauses in the banking agreements. So that is not an issue at present. But in terms of which court is the right court, Your Honour can have absolutely no doubt that this court is the right court for all of those proceedings. Why? Because some of the claimants are DIFC establishments. And so there is jurisdiction under Article 501A of the Judicial Authority Law, regardless of any jurisdiction agreements. So there's no sensible answer to that position. And as regards the respondents, there's no answer at all to the question of whether or not there is a binding jurisdiction agreement imposed to which they are a party. In terms of whether or not the JJT application makes any difference, it seems to me that that must turn on whether or not Your Honour considers that the JJT has jurisdiction, which in turn must turn on whether or not there is a conflict of jurisdiction. So if Your Honour finds that there is no conflict of jurisdiction, at least not yet, then it must follow that the JJT has no jurisdiction, and therefore it must follow that an abusive application to the JJT in those circumstances can't be a mechanism to block DIFC court proceedings. But I'll come on to that perhaps. It's not a point that's raised against me, but that's the outline of what I would say in relation to that. In terms of this court's power to grant an anti-suit injunction, there's absolutely no doubt that the DIFC court has jurisdiction to make anti-suit orders on either of two grounds, which are the English grounds, on the basis that there's an agreement, that the foreign proceedings are brought in breach of a contractual obligation. So that's the exclusive jurisdiction agreement in this case. In other cases, it's been an arbitration agreement, the negative pledge in that. And the second is the vexatious, oppressive, and unconscionable ground. And actually, in relation to all of this, although it is denied that the Dubai court proceedings are vexatious, oppressive, and unconscionable, no defence, no substantive submissions are provided to you in relation to that. The only point that is taken against me is that the claimants have delayed, it is said, in bringing this application. So it's not disputed that Your Honour has the power, and indeed it's not disputed that the approach of the English courts to these sorts of applications is the right approach, notwithstanding that the proceedings are in Dubai. But let me just show you those cases where Dubai courts have been affected. The first, and I won't show you the whole of the cases, I'll show you some extracts from them. The first of them, it's in bundle H, tab 7, and it's called Brookfield Multiplex, and the page is at page 86. And the judge went through the English authorities, and in particular was dealing there with the question of whether or not a court which was not the supervisory court of an arbitration could nevertheless make injunctions in support of that arbitration, drawing that distinction. And there was an argument in that case about whether the seat was DIFC or non-DIFC. And you'll see at the bottom of the page, paragraph 38, I do not therefore accept that even if the seat of the arbitration is non-DIFC Dubai, the court has no jurisdiction to grant an anti-suit injunction, but it would be an unusual and exceptional case where the court did so, particularly bearing in mind the appropriate respects that the courts of the two different systems in the Emirate of Dubai must have for each other, and then mentions two cases which my learned friend wants to address you on, which are early cases indicative of that level of caution. But the point to be made here is that this was going to the question of whether or not the DIFC court can injunct Dubai court proceedings when it was a Dubai arbitration, Dubai seated arbitration, non-DIFC arbitration. So the judge was saying, I've got power even in those circumstances. But in fact, what he found was that on his construction of the arbitration agreement, it was a DIFC seated arbitration agreement. And therefore, in those circumstances, if it had been the case that the Dubai court proceedings had been conflicting with arbitration, he would have been in a position to restrain them. So in that case, though, the final conclusion was, so you see that at paragraph 41, for example. If the seat of the arbitration is DIFC, however, the position is different because the primary responsibility for the enforcement of the arbitration agreement would lie on the courts of the seat if relief was sought. This court would then be concerned first to protect its own exclusive jurisdiction under the judicial authority law, and secondly, as the court of the seat, to protect the agreement of the parties to refer their disputes to the determination of arbitrators if there was some infringement of the parties' rights. So he then goes on to consider the question of seat, decides, though, in the end, at paragraph 47, that he doesn't need to reach that conclusion because there was no breach of the arbitration agreement, but a clear indication that in the appropriate circumstances, certainly in relation to the enforcement of a contractual promise, this court will enforce contracts. One might say that's what an international court is for, primarily. The next case that I would show you is the Hayri and Hazim case, and that is found at tab 22. This was also an arbitration case. What we've got here, and unfortunately the judgment's a little unsatisfactory because what we have is an order, and then we have a judgment on the ex parte, and then a judgment on the return date, the adjourned return date. But just to draw your attention to the order at page 402, paragraph 2, you'll see, firstly, at 1, it defines the dispute, and then says at 2, until the return date, the defendant shall not, and then assist pursuing, first, the Pakistani proceedings, but secondly, any other proceedings relating to the dispute in any court, or other dispute resolution other than the DIFC courts, and that became an arbitration. So the effect, although in that case, the target of the injunction was Pakistan proceedings, the effect of the injunction was to prohibit Dubai court proceedings and indeed Dubai arbitration, and that became relevant subsequently. You can see the rationale for this if you go down to page 405, paragraph 4, and simply being the English approach to enforcement, to enforce the negative pledge in an arbitration agreement, and it's the Ust-Kamenogorsk case from England, and applies the strong reason test. So that, in other words, an anti-suit injunction is to be granted, preventing breach of that agreement unless there is a strong reason not to do so. And everybody agrees that that is the test that Your Honour is concerned with today. And then paragraph 409, page 409, I believe, paragraph 8, you will see there the judge then subsequently, just a few days later, I believe it was about 10 days later, or maybe 2 weeks, paragraph 8, the judge says, in those circumstances, the right thing to do, nothing had changed, he said, so in those circumstances, the right thing to do is treat this as the final hearing of the application for an injunction and to grant an injunction in the terms which have been sought, and then and you'll see it's both a negative and a mandatory injunction in relation to the proceedings in Pakistan. So that, as I say, it was targeted at Pakistan, but prevented proceedings in the Dubai courts as well, or in Dubai arbitration indeed. And then the final one where injunctions have been granted is the case of Ludhian, where, as I've mentioned, I think we only have the order, but you will see there on page 617, tab 30, that is the order of Justice Shamlan. And then it's the penal notice. This is and then over the page, this is an anti-suit injunction against Lucena, and then declaration. He declares that the DIFC courts, what 3B, have exclusive supervisory jurisdiction over the DIFC LCI arbitral proceedings, and then the respondent A must not take any further steps in the Dubai court, case number 234 in the Dubai courts, save for the steps set out immediately below, and B must discontinue those proceedings forthwith. So there, an interim order made both mandatory and prohibitory, directed against Dubai court proceedings. And then, although they weren't considering an anti-suit in terms, the issue arose in the case of Lural, which Your Honour might be familiar with. You probably knew it under a different name, but that is at tab 31. And just to remind Your Honour, this is a decision of February, where Your Honour's court, in the Court of Appeal, found that a decision of the Abu Dhabi courts was not to be enforced in the DIFC courts because it was obtained in breach of a jurisdiction agreement in favour of the DIFC courts. And if we go down to page 600, I think it's at the bottom, 26, paragraph 20 of that, you will see that the Court of Appeal contemplated, at least, an anti-suit injunction to prohibit that sort of action. So again, not in this case Dubai courts, but dealing with the Abu Dhabi courts. Paragraph 20, it's accepted by the respondents that anti-suit injunctions can be issued by the DIFC courts in relation to such clauses which operate in favour of the courts of the DIFC. And it was submitted that this was the course which Lural should have adopted in order to prevent the Abu Dhabi courts proceeding to a judgment which had the effect of depriving the DIFC courts of their own jurisdiction. And then if you look at 21, in the absence of an anti-suit injunction in respect of foreign proceedings, which is harder to obtain than a stay in the foreign court, the parties will otherwise need to engage in an ugly rush to judgment of the kind deprecated in the English authorities relating to foreign non-convenience in order to gain res judicata status. And then if we go down to paragraph 29, you'll see on page 628 at the bottom right, in the middle of the paragraph, talking about conflict of final judgments from different emirates in this case, and the USC's jurisdiction to deal with them. Such a conflict only arises where there are conflicting final judgments on jurisdiction, with the result that the point could not have been taken earlier unless Lural had sought an anti-suit injunction and obtained final judgment in relation to it. It cannot be said that Lural were obliged to do this, and any failure to do so cannot impact on the proper construction. So clearly the point arose in that case in a different way. What was being said was effectively the respondents to the appeal were the authors of their own problems because they hadn't applied for an anti-suit. But everybody was accepting that an anti-suit could be issued in respect of Abu Dhabi proceedings, and I note also could be issued notwithstanding the provisions of the Union Supreme Court legislation, which provide for determinations as to disputes of jurisdiction and disputes of and final judgments in respect of courts issued by courts of two different emirates. So the fact there is that machinery didn't appear, at least in that case, to count against the prospect of that sort of injunction being issued. And as I say, I detect from my learned friend's submissions no suggestion that this court can't make that sort of injunction to enforce a contractual right or a negative jurisdiction agreement in particular. That there is some reference to some of the cases in respect of the unconscionable, vexatious and oppressive ground where there were two quite early decisions in cases related to a case called Talim, where the court refused to grant injunctions. But I don't see anything, any suggestion that there is any particular sensitivity to this being Dubai court proceedings that is being raised by the defendants. And indeed, the cases that I've just shown you indicate that there's no particular sensitivity to that in the decisions or in the cases or in the contemplation of the courts or indeed practitioners. Your Honour said, well, isn't it more of a problem if it's sort of intra-emirate? I would suggest not, because the concerns that the courts have when they're granting anti-suit injunctions is generally one of the questions of comity, which is that is a question of respect for the courts of other states. In effect, it's not really. I mean, one has to obviously be sensitive, and I'm not suggesting that you should just run around making anti-suits at any suggestion, but nevertheless, actually, there's certainly no greater sensitivity that it's Dubai courts than there would be, certainly, than it's another emirate, for example, where the judges are appointed by a different ruler of a different emirate, or indeed a different state, where you have governments or people, or however they go about electing or appointing their judges, who have been appointed by that other nation. One would expect a greater sensitivity. And the point that I was making about anti-suits is that when they first arose, they arose in the English courts of equity as a means of regularizing procedurally what went on, because you often found that there were parallel sets of proceedings in both sets of courts, and there were no rules to regulate that, and so that's the situation in which the anti-suit was actually developed. It's obviously not used in that context in England anymore because the rules provide for it, but where they did not provide for it, then the anti-suit was developed to fill that gap, and that's the gap that could be filled here. The other test that there is over and above the question of jurisdiction agreements is the vexatious and oppressive ground. That test has been applied before, albeit not successfully, not in respect of Dubai court proceedings. There was a case called EDF Mann and Hussein, where the test was stated to be the correct test by the current Deputy Chief Justice, but in fact, on the facts of that case, the foreign proceedings were found not to be vexatious and oppressive. I don't think I need to take you to that unless you'd like to look at it.
No.
I'm grateful. So the first ground then, on the facts of this case, the first ground is the jurisdiction agreements. And it might, I mean, I don't know whether Your Honour wants to look at it, but I can show you the jurisdiction agreement that we have. There's no particular points to be made on it, but there's an exclusive jurisdiction agreement in favour of the DIFC courts.
Is it one of those agreements that requires the banks to elect?
Yes, and there's no issue taken as to that.
Yes. All right.
So there's been an election in favour of. I mean, I can show you it if you like. Or
no. If it's not disputed, if it is disputed, Ms. O'Sullivan will tell me. But otherwise, we can assume that it's not disputed.
No, and although they don't concede it finally, if I can put it like that, they accept that whatever the evidential burden, whatever the standard is on this occasion, it's satisfied in regards to that jurisdiction agreement. So they accept that the case is made out, if I can put it like that those agreements exist and that they're binding on the defendants. So I don't need to trouble you with any of that. As I've mentioned, only D3 in the Dubai courts has actually said this is a forgery. What the Hadef defendants have said in the Dubai courts is I showed you the passage where they say that they suspect the documents, but they don't feel able to raise those suspicions in this court, and they certainly have not positively alleged anywhere that they don't exist, and that would be wholly improbable in circumstances where that they actually have relied on the terms of the agreements themselves in their application to strike out. So this is a very clear case of proceedings being brought in breach of an exclusive jurisdiction agreement. No defence is offered to that, and so we say that Your Honour should enforce that agreement unless there is strong cause to do so. The strong cause that is alleged is delay. That's alleged in relation to both grounds, if I can put it like that. So what I'll do is I'll just explain to you why I say this is also a vexatious case, and then I'll come back to those delay grounds in a moment, if I may. So the vexatious ground is made out, we say, quite plainly. Now, the defendants deny this, but it's just a bare denial in their skeleton argument. They don't address it. They don't try to explain or defend their conduct in starting, well, effectively applying for judgment in this jurisdiction, and then starting proceedings in another jurisdiction. There's a two-part test on the vexatious and oppressive ground. The first is this court the natural forum? And the answer to that is it clearly is. Not only do we have the exclusive jurisdiction agreements, we also, as I say, we know that the first, second, third, fifth, and eighth claimants are all DIFC establishments. So they either have branches here or established here. And what that means, under the principles that are long familiar, the Corinth case and then the follow-up to that, and in particular the Tavira case, which is in the bundle, which I don't think I need to take you to, it is that this court, under Article 5A1A of the DIFC Judicial Authority Law, has exclusive jurisdiction over any claims brought by those parties, whoever they're brought against. And
even if they're brought jointly with non-DIFC establishment claimants?
So any claim that is brought by a DIFC establishment at all is Your Honour this court has exclusive jurisdiction over. And then the question becomes, what about the other claimants? And we say that those are necessary and proper parties to the proceedings under the Nest Nest Investments jurisdiction. So that's the 5A1E. But either way, because it doesn't, that's the point, that it doesn't make any sense to split out claims of that sort. And so if you've got substantial connection through that first route, or any other ground, in fact, then you can add on defendants to that. So we say this is not just the natural forum, contractually and as a matter of the law. This is the only forum in the Emirates that can hear this case. So that's the first part of the test. And the other aspect of it all is that these defendants have submitted, and as I say, applied for determination of the claim in their favour. And it was only after they lost that application that they revealed the JJC application and then sought a stay of these proceedings, which is what Justice Cook called an appalling abuse of process. So this, we say, is an absolutely classic case of vexatious and oppressive conduct. And if you want an example of the kind of cases that we rely on, if you look, Your Honour, at Bundle H, tab 42, for example, it's the Star Reefers case. If Your Honour goes down to page 825, using the numbering at the bottom,
yes.
And you'll see the passage there on the second column, about 3/4 of the way down the page. It starts, thus it has been recognised that the unconscionability of the foreign claimant is often to be found, mainly or substantially, in the very reason that he has first submitted to English jurisdiction as the forum where the parties' dispute will be resolved, and then sought vexatiously to extricate himself from the consequences of that submission, or oppressively to prolong or multiply the litigation by commencing further proceedings abroad. And then goes on to say at paragraph 31 of that in effect, the weakness of the case in the foreign proceedings can be relevant to the exercise of the discretion, or the exercise of the assessment of whether it's abusive conduct. And we would say, by extension, by logical extension of
Sorry,
that.
Mr. Montague-Smith, I just dropped out for a little while there. You were reading to me.
Oh, so I was reading to you from page 825, going with the numbering at the bottom, and it was a passage about 3/4 of the way down the page. Your Honour's frozen. I think that we may have lost the judge again. Zoe, can you still hear me? Sorry, sir. Okay.
Yes, I can.
Great, thank you. I think we've lost him.
again. You were reading to me from Star Reefers when I dropped out.
Thank you, Your Honour. Can you hear me now?
Yes, I can hear and see you. Thanks.
Perfect. So I was the Star Reefers case. What I was reading to you was about 3/4 of the way down,
Yeah.
page 825 on the right-hand column. It has been recognised that the unconscionability of the foreign claimant is often to be found, mainly or substantially, in the very reason that he has first submitted to English jurisdiction as the forum where the parties' dispute will be resolved, and then sought vexatiously to extricate himself from the consequences of that submission, or oppressively to prolong or multiply the litigation by commencing further proceedings abroad. So it's a classic case of vexation and oppression. And then paragraph 31, just to add into the mix, we were also shown, this is over the page 826, we were also shown a number of authorities where the weakness of the case sought to be pursued in the foreign court has been the subject of comment. And then it says, Lord Justice Lawton said that the weakness of the evidence is a factor which can be taken into account together with more weighty factors in deciding whether conduct is unconscionable. Now that is probably talking about the weakness of the merits of the claim, but we would say the logic also applies to the weakness of the assertion of jurisdiction, in terms of whether this is a vexatious conduct, starting a claim in a place where you know it has no jurisdiction. We would say makes this even more vexatious. I think perhaps the best thing to do in terms of the other cases on which we rely, if Your Honour has my skeleton argument, I'll just draw your attention to a couple of no, in fact, let's go to, sorry, if we go to tab 46, page 880.
Yes.
So again, I'm using the bottom numbering, 880, paragraph 13. There's another case called Tonic Star. This is on very similar facts to the current case. So what happened was that the claimant, well, it's different facts, but essentially the same issues arise. The claimant brought a claim in England. The defendant applied to stay it under Section 9 of the Arbitration Act on the basis that there was arbitration agreement. But the parties couldn't agree on a seat. And so the claimant said that they were going to apply to the English court to determine the question of the seat. And what happened then was the defendants went off to the New York courts seeking to compel arbitration and seeking to restrain the English proceedings, which they themselves had made an application in. And what the judge said was there, paragraph 13 on page 880, the question is whether the court is satisfied that AHA have behaved unconscionably or oppressively or vexatiously. In my view, they have. It seems to me that AHA have tried to hijack the decision which is presently before this court, namely whether the arbitration clause is apt to embrace the disputes between the parties, and if so, where its seat should be. The syndicate is a stranger to the Federal Arbitration Act. It is not either expressly or by implication agreed that the Act should determine the matters in issue, even if, as Mr. Elton asserts, the New York court would give full effect to the English law when construing the arbitration clause. The terms of the Act itself and the evidence before me as to how the Act operates suggest at least that in the absence of an express choice of seat, the seat will be the Southern District of New York. The written material relating to AHA's claim under the petition reflects a body of law which has nothing to do with the interpretation of a contract governed by English law. Decision by AHA both to make a Section 9 application here and then immediately afterwards, without prior notice, to present a petition to the New York court is, in my view, at the very least to be described as oppressive. The effect of their conduct is to seek to preempt this court from reaching its own decision on the arbitration questions. AHA no doubt hoped that their tactic would lead to an earlier determination by the New York court, which would then be invited to restrain the English court from considering the issue, or at least arguing that the decision of the New York court was final and binding as between themselves. So it was an attempt to hijack the proceedings, take an issue which they'd already agreed should be determined in one court to another court, and then use those proceedings to try to prevent proceedings in the original court. That's on all fours with this case, we say. And we refer to another case, which I don't think I need to take you to, which involved competing proceedings. But the effect in this case has been to interfere with the claimant's right to proceed in their chosen jurisdiction. Do we still have?
Yes.
Sorry, she's gone from my. Thank you. And that has been effective up until this point, and that has had the result that the Dubai proceedings are about to proceed to some sort of judgment. So there's been a march has been stolen. So we say that this is a classic vexation and oppression case. In terms of the order that Your Honour is asked to grant, we seek both prohibitory and mandatory injunctions. We seek a mandatory order, which therefore requires discontinuance, because a prohibitory injunction may not be enough to ensure that the injunction is effective. And this was an issue which was looked at in the case of specialised vessels, which you will find in bundle H at tab 66. It's page 1180 of the bundle. And you'll see the test that was applied there at paragraph 56. Under the heading mandatory relief, in summary, paragraph 56, if a prohibitory injunction may not be enough to ensure that the injunction is practically effective, e.g. where the foreign action has a life of its own, a mandatory injunction requiring the injunction defendant to discontinue the foreign proceedings may be granted in an appropriate case. That now appears to be this case. I don't think we were aware of it, but it turns out that both parties have asked at least the Dubai courts to stay their proceedings. Quite recently there was a suggestion, at least in one of the submissions by the defendants, but the claimants certainly have asked on multiple occasions. There's never been any decision as such, there's never been any determination of those stays, but no stays have been issued. So in addition, the other part of the problem is obviously, broadly for the reasons that Your Honour identified, the third defendant is not a respondent to the proceedings. So the proceedings have a life of their own, quite apart from their being in the Dubai courts. Unless the Hadef defendants, who are respondents today, withdraw their claims, then the third defendant may well be in a position to block any stay of the Dubai court proceedings. An attempt has been made to resolve this by asking all of the Hadef defendants, including the third defendant, to give an undertaking to lend their weight to lend his weight to a stay application, but he has refused to do that. And so in those circumstances, despite the fact that he's represented by the same party, Hadef and Co., the same firm, Hadef and Co., he's refused. And so in those circumstances, we say that it is a fairly swift inference that he intends to resist any stay that is sought. So you will have Hadef both asking for a stay and resisting stay on behalf of different clients, seems to be what will happen. And one can see that that's quite unlikely to have the desired consequence. Mandatory interim injunctions or anti-suit injunctions are regularly granted where there is a breach of a jurisdiction agreement. We've given you some authority for that, but let me show you one paragraph. It's Comic Group, which is at tab 10. And if you go, please, to page 172, paragraph 39, you will see I turn therefore to Comet's application for a mandatory injunction that UNICA should apply to the French courts for the discharge of the judgment made on January the 10th, 2003. The court has in personam jurisdiction over UNICA and can grant such an injunction. Before a mandatory injunction is ordered, the case must be unusually strong and clear. And then goes on to say mandatory injunctions are not normally granted in interlocutory applications, but if the case for such an injunction is sufficiently clear and justice requires that a mandatory injunction should be granted, then the court should grant one. And then says, one of the circumstances in which mandatory injunctions are regarded as appropriate is where the injury complained of is in breach of an express agreement, such as the provision. And in such cases, a mandatory injunction is usually granted at trial. And so the question is, does Your Honour feel confident that there would be, if there was to be some sort of trial of this action, a mandatory injunction, and then subject to the points that are made against me on delay, which I will address, then Your Honour can be clear that there is no real response to an application for an anti-suit. So an interim mandatory injunction can be granted today. We also refer to the Masri case as another example, where an interim mandatory injunction was made in a vexation case. so not in a jurisdiction agreement case. And in that case, the defendants had submitted in England and then litigated elsewhere, and that was sufficiently plain for there to be an interim mandatory order. So we say whichever ground you're looking at, it's very, very clear. And this is all subject to what my learned friend says about delay. And as I say, that really is the only point that's taken against me in the skeleton that was submitted yesterday. Now I can deal with that now. I can hear what Ms. O'Sullivan has to say about delay.
It might help if you dealt with it now, Mr. Montague-Smith.
All right. I mean, so what is said is that the claimants should have appealed against Justice Cook's order and should have then applied for an anti-suit injunction after that. So that's their position. And that is, they say, delay that should count against, in fact, determinatively against Your Honour granting an anti-suit injunction. Now, I accept that in principle, a failure to seek relief promptly may be a ground to refuse an anti-suit injunction. However, whether or not it is a ground to refuse is always a fact-sensitive assessment. How do you go about making that assessment? This was summarised recently in the case, one of the cases I just took you to, which is a case of specialised vessel services. That's behind tab 66 in bundle H. And if we go to page 1176, you'll see there the summary that is adopted from the Raphael on anti-suit injunctions, paragraph 35. So what is said is the significance of delay will depend on all the circumstances of a particular case, but some principles have been identified in the case law. First, even where there is a binding exclusive forum clause, the injunction should be sought promptly and before the forum proceedings are too far advanced. Second, the questions of delay and comity are linked. The more closely that the foreign court has become involved with the matter due to delay, the greater the interference with foreign court that an injunction is likely to produce, and so the stronger the factors against the grant of an injunction. Third, prejudice to the injunction defendant due to delay is significant, and if delay is not prejudicial, it may be considered given significantly less weight. But delay is not necessarily immaterial in the absence of prejudice to the injunction defendant. The need to avoid delay arises from a variety of reasons, including in relation to the prejudice of the injunction defendant, waste of judicial resources, the need for finality, and comity towards the foreign court. Fourth, and perhaps most importantly, the courts will take into account the extent to which the delay was justifiable or excusable in the circumstances, and will weigh delay against the importance of enforcing the forum clause. Even delay that can be criticised will often not be sufficient to justify refusing an injunction and thus permitting a breach of contract to continue. It seems that time taken in challenging the foreign court's jurisdiction does not in itself justify delay in applying for an anti-suit injunction. So broadly, you are looking for the reasons for any delay, the impact of any delay, and then the broader circumstances of the case, all of which are going to be relevant. When you're considering the reasons for delay, there's some useful guidance on the test, which you will see if you just go back one paragraph in this judgment, paragraph 34. There's a quote from the Qingdao and Shanghai Din case, and you'll see there some three relevant principles that have been identified and are being applied and summarized in this case. First, there's no rule as to what will constitute excessive delay in absolute terms. The court will need to assess all the facts. Second, the question of delay and the question of comity are linked. The touchstone is likely to be the extent to which delay in applying for the anti-suit relief has materially increased the perceived interference with the process of the foreign court or led to a waste of its time or resources. And third, when considering whether there has been an unacceptable delay, a relevant consideration is the time at which the applicant's legal rights have become sufficiently clear to justify applying for anti-suit relief. So the question then, and that latter principle is quite helpful in identifying, has there been any culpable delay in this case? Can it be said that in July 2020, the claimant's rights to apply for anti-suit relief were clear? And we would say in relation to that, obviously not. So this court had told us that we could not make that application. It imposed the stay as a result of the defendant's actions. and at their request. So the defendants on the one hand are saying, well, we told the court and the court accepted that there was just nothing further that could happen in this case until the JJC proceedings have been completed. But at the same time, they're saying, oh, but you should have appealed, which we would have resisted. And then once the appeal was decided, you should have made your anti-suit injunction application at that stage. So they, all of this, none of this would have come about if they had told us about the proceedings, the Dubai court proceedings and their plan in advance of the hearing of the 30th of June. And we now hear, well, it sounds like it's wrong that there was actually a hearing on the 30th of June. But in any event, at the same time that they were filing their claim with the Dubai courts, on that same morning, leading counsel, who's not leading counsel today, it's a different leading counsel, was telling the judge that the determination of issues of privilege, for example, should just be adjourned. And there was reference in his submissions to our position that 1 or 2 weeks wouldn't be a problem. And the judge had said, in relation to the immediate judgment application, when there was a listing dispute as to that, that issue needed to be determined speedily, was the word he used. And in relation to privilege, the words he used were as soon as may be. So there was no doubt at that time that the judge was operating under the assumption that there'd be no problem with listing those sorts of applications to come up very quickly. And the defendants allowed the judge to continue the hearing operating on that assumption, on that false assumption that the proceedings would carry on as normal, when they knew that they were lining up to torpedo the action in accordance with the then prevailing practice of the court. Now, had we known about that, had they done what they should have done, then we could have applied at that stage before the stay was imposed. But having successfully concealed the proceedings and then deployed what has been described already as an appalling abuse of process, they then use that to block any further action in these proceedings. And the submission is that it's our fault for not applying sooner. Frankly, the fact that that is the submission that is being made in response to this injunction application, that is the only thing the defendants can find to say in response to the application, I say demonstrates that this is a case that is just as plain as day, that there ought to be an anti-suit. The question is whether and when the claimant's rights to seek an anti-suit were clear. And parties, I would suggest, are not required to embark on attempts to change the law to achieve that. There was some suggestion, I think it was put by my learned friend that a change in the law wasn't a material change of circumstances going to the first case, but clearly there was a sea change in the court's attitude to JJC applications with Lacan. The universal view up to that point was that there had to be a stay whenever JJC proceedings were started. We see that in the Lacan decision itself. You'll recall it when repeating the decision of the first instance judge. The judge below simply called it the court's practice. And in this case, the judge actually checked with the registrar, came back on the phone, and then said, I have no option. This is just, once it's been filed and once the fee is paid, I have to stay the proceedings. And to my shame, the leading text in the jurisdiction, the DIC court's practice, also expressed it that way. The shame is spread because between us, Mr. Harris Borg, my learned friends junior, and I reached the conclusion that was the practice of the court. And in my defence, and in Mr. Borg's defence, I think that really was the practice of the court. It's impossible to reach the view that Lacan is really anything other than an absolute sea change in the court's approach to those applications. And so it was reasonable to wait. The other point on this front is that the judge gave us some indications as to what we could expect. And he went away and came back, and he said, there is no reason to think that the JJC cannot deal with this promptly. Why? Because there had been problems before, there had been unhealth amongst members, but there was now no unhealth. There was no backlog whatsoever, and so they would be in a position to deal with this promptly. So that was what was anticipated, that we could, as a choice, what do? Do you try and change the law and then apply for anti-suit, or do you wait and see the prompt decision that's going to come? Now, the question of whether or not there is an objective basis for that sort of assessment can be important. So if we go back to the specialised vessels case, if you look at that case at paragraph 30, what had happened there is citing a case called SR shipping, and an anti-suit injunction was refused. And in part that was because of the way in which, because it wasn't brought promptly, and one of the explanations was that some action had been taken to challenge jurisdiction, and it was expected that that would be resolved speedily. And so therefore one of the reasons for refusing the anti-suit, and you'll see it recorded in the embedded quotation at paragraph 30, so it's paragraph 61 you'll see of SR, at sub little Roman numeral 2, there was no objective justification for thinking the Qingdao jurisdiction challenge would be resolved speedily, and 3, there was no objective justification for thinking that the Qingdao jurisdiction challenge would be successful. So that was a problem in the SR case, but if you scroll down to paragraph 52, you'll see the approach of Mr. Justice Culver in this case, where he says at paragraph 52 on page 1180, unlike in SR at 61, in the present case, SVS had objective justification in the form of its Nigerian legal advice for thinking that its challenge in Nigeria would be resolved speedily and successfully. Once it became apparent that its swift and efficient resolution was unlikely, it brought these proceedings. No prejudice has been caused to MOP in the meantime. So the fact that there was objective justification for that view was important in that case. Taking those principles into this case, we were told in terms by the judge that we could expect a speedy decision. That's E512. And as to success, well, look at what we're faced with in terms of jurisdiction. There's no basis whatsoever for asserting jurisdiction in Dubai. The defendants don't even bother to defend their actions or try to make a case on that today, because there's no defense to that. So the Lacan decision came out. As I said, the decision was made in April, but it wasn't made public immediately. It was anonymized. I don't know when it was made public. It first came to my attention in May. But I believe that, as I said, my learned friends in some of their submissions suggested it was late April when it was issued. But then by mid-May, we were told that a decision had been made in the JJC. That's Miss Davis's evidence, mid-May, and that it was just awaiting signature. And so at that stage, it's fair to say, well, there might well be wastage if we get a decision from the JJC having issued this application. And then only then on the 20th of June are we told that the Dubai courts are going to issue judgment on the 28th of July. And even then, the JJ decision is expected imminently. And it's only, I think, in the early July that a decision came out of the JJC, and ours was nowhere to be seen. So, of course, we're back to the position where it's just indefinite. We just have no idea why this decision is going to hasn't come out, or whether it will ever come out. So in the course of that, it's being said, we're supposed to walk this line between applying too soon or applying wastefully on the one hand, and applying too late. And indeed, some of the authorities the defendants have put in emphasise that parties should not apply too soon, albeit, as I say, that's early authority. But effectively, my point is that the defendants have created this difficult balancing exercise. They resisted this application being heard. Even today, it is with respect wholly unfair to criticise the claimants for the way, the timing of this application. So that's the question about criticism. But as I've shown, Your Honour, the next question is, well, even if there's criticism, one has to show that it has some impact, some negative impact on the amount of resources that are being expended on it, or some sort of prejudice. What difference did it make? As we've seen, very little has actually happened in the Dubai courts. There are various hearings between the 30th of June and the 9th of March, but they seem to be case management hearings. Nothing of substance appears to have happened at them. apart from plaintiff requests which haven't been heard for stays. But one has to ask, how many of those would have been avoided even if the claimants had done what the defendants say they were supposed to do, which is first appeal the Cook order and then apply for an anti-suit injunction. As I've said, the defendants resisted this application coming on when it did. So absent this impending judgment on Wednesday, they would have required, and no doubt would have received, a much longer run-up to this application. They would have demanded the usual 28 days to put in their evidence, for example, as they did on the immediate judgment application. Your Honour will know, realistically, getting to the end of an appeal in 6 months is optimistic. It can happen. In Lacan, that's how long it took. It took 6 months. So the decision was made in October, and then the appeal decision was issued in April. So it's about 6 months. You can see that from the decision in Lacan. So realistically, had we appealed, we would have probably been wrapped into the Lacan appeal. If one thinks about if the Court of Appeal had been faced with 2 identical appeals on the same grounds, they would have wrapped them up together and would have heard them together. So realistically, had we actually gone down the route that the defendants say we should have gone down, it's very unlikely we would have got anywhere with it until April at the earliest. And then you've got to build in time for the anti-suit. And so unless that process has been accelerated, which it has in this case because of the impending judgment, you're looking at application of this sort on with responsive evidence and all the rest. A heavy application is likely to take 3 months to get on in this court. Would we have actually saved ourselves anything in the Dubai courts as a result of all of that? Realistically, we would have been bumping right up against the judgment date on Wednesday, whatever we had done. And in terms of actual activity, as I say, there hasn't been much. All that's happened is that the claimant's counsel has submitted a power of attorney, produced the original of the third defendant's guarantee in March, and then there's been an exchange of submissions on forgery allegations, but those are extraordinarily brief. You will see them, I can show you those if it's helpful. They're in bundle C. If you'd like to look at them later, perhaps at page 641.
They're the forgery allegations.
Yeah. So what happened was there was a claim form which I've shown you, and then on the 23rd of March, the defendants produced a memorandum on the forgery allegations. But effectively, what they do is simply repeat what they said before in their claim form. So it's very similar. I can show you that if you like. We go through the exercise. If you take up bundle C641.
Yes.
So I showed you at 534 the claim itself. If I then show you 641, but as you will see, most of that, well, a lot of it is heading, and then we go down to 646, which deals with the third defendant's position. So that's irrelevant for today's proceedings. It's not until you get to 652 that you get the submissions from today's respondents. Third plaintiffs insist on questioning and challenging the documents. They don't actually say anything very much about it, and effectively reformulate, repackage what they said before at C542. And then they just repeat the arbitrary demand for damages, which you'll find at 656, just continues to be completely unexplained, and you'll recognize that from what they said previously at 548. And then at 658, you see the request for the appointment of a banking committee expert, which again repeats what was requested at 549. We've got no evidence of any cost associated with any of that to establish any prejudice. It's impossible to say with any confidence that any of that would have been avoided if we'd appealed and then applied. That's March. And anyway, we say any cost that there is was caused by the claimant's own breach of contract in going down this route in the first place. So it's absolutely not right to say that, sorry, I'm getting messages. It's absolutely not right to say that the Dubai court's case has progressed substantially. It's certainly not as a result of any delay or choice that was made by the claimants. Certainly no decisions have been made on jurisdiction or on the merits in the Dubai courts, and none of the claimants' attempts to stop the proceedings have been determined. So if we go back to the guidance from the specialised vessels case, which hopefully you still have open, if you look at paragraph 47 and see what were the factors that were important there when considering delay, 47 talks about what has happened or what hasn't happened in the Nigerian proceedings in that case at paragraph 46. And 47, when this fact is taken into account, together with the fact that A, proceedings have not progressed at all substantively on the merits in Nigeria, B, the English court is not being asked to second guess any decision of the Nigerian court, and C, MOP has at no stage suggested that the arbitration clause is for any reason invalid, nor has the Nigerian court made any finding to that effect, I do not consider that the delay in bringing this application should count as a decisive factor against the grant of anti-suit relief, if that would otherwise be appropriate. That was a case in which a year's delay, over a year's delay in bringing an anti-suit, but what had happened is they got bogged down in jurisdiction debates in Nigeria and nothing had happened. And so a year later they came back. There wasn't this additional factor that the court that they were applying to had told them they couldn't make any applications, which is what was the position in our case. So all of those factors we say apply in this case. But there's another supervening factor in this jurisdiction. Given the defendants do not dispute the jurisdiction agreements, and given that some of the claimants are DIFC establishments, then this court can have confidence that the JJC should decide jurisdiction in favour of the DIFC courts. And if they do, everything in the Dubai courts will be wasted anyway. And this is not a situation where different judges could take different views about which court has jurisdiction and which doesn't. In this court, the defendants find themselves completely unable to put up any reason whatsoever for reaching a different conclusion. So their position today would have to be, A, we can give you no logical reason why the JJC should find in favour of the Dubai courts, but in any event, we might be able to persuade them to do so. It is, with respect, a completely unattractive position to take. So on the basis of that, if what's really at play is trying to make sure that no time is wasted in Dubai courts, you ought to be starting from the position that is all wasted time anyway. And let's not get to that. All you'll be doing is saving further wastage of time. So as I say, we don't accept that there has been culpable delay, and if there has, the courts have emphasised that there shouldn't be too strict a standard to be applied. You've seen there was a year in specialised vessels. There's also reference in that case, you'll find it if you go there at paragraph 33, to another case called Gossub, where the judge found there was no relevant delay, even though he decided that matters might have progressed more quickly. So even if there were delay, it was reasonable, we say, and it resulted in no prejudice and no wastage of Dubai court resources. If you look at it from the other side, refusing relief would deprive the claimants for all time of the right to enforce their jurisdiction agreement. It would reward the defendants for conduct which we say this court ought to be condemning in the strongest terms. And not just with words, because that doesn't seem to make any difference, with actions, it seems in our submission. So this court, we would suggest, needs to show parties through its actions, and therefore the legal community, that it is not possible to gain advantage by acting abusively in this way and by concealing that abuse. In my submission, we are at a point where court users, prospective court users, investors into the DIFC need to see a strong signal from this court that it can function properly and that it will protect its processes, despite all of the difficulties that are introduced by this legislation. Yes. Otherwise, this will continue. Your Honour, those are my submissions.
Thank you, Mr. Montague-Smith. Ms. O'Sullivan.
Thank you, my Lord. Again, we have put in a fully argued skeleton argument, and so I'll keep my oral submissions brief, and I'd invite you to read the skeleton and the cases referred to in it.
Yes, which I've done. Is it right that your only point really is delay? Yes,
except that delay, as I'm going to explain, delay, it's slightly more subtle in that there's an interrelationship between delay and comity, in that, but I'll come to that. But yeah, essentially, so it's delay and comity, or the increased comity problem given the delay.
Yes.
So, because I do accept that the jurisdiction exists for this court to make an anti-suit injunction, but it's a vanishingly rare case in which that actually happened. In fact, my learned friend was only able to identify a single case, which was the Ludian case, in which an injunction has been made in respect of proceedings in the onshore Dubai court. And we only have the order there, we don't have the reasons. The other cases he cited were in a different category. In Brookfield, that was not an injunction to prevent proceedings before the onshore courts, and no injunction was made. In Hayri, as he fairly said, that was concerned with preventing proceedings in Pakistan. And he also referred to the Lural case, in which no application for an anti-suit injunction was actually made, and the argument was that it should have been made. So that is, there is only one case he can identify in which such an injunction has actually been granted. And we have referred you in our skeleton to a couple of the early cases in which the courts expressed caution based on comity. If I could just take you to the Ziad Azam case, it begins at H1156, but I want to take you to paragraph 25, which is at page 1164. And this has the advantage of also referring to the previous decision, where the court refers to the earlier decision of Justice John Chadwick in Talim and National Bonds.
Yes, thank you.
I mean, I'm sure you're aware of that. I won't read it out, but I refer you to that. And he says at paragraph 26, I concur with the idea. It's unlikely to be helpful. Of course, this predates the establishment of the JJC.
Yeah.
Now, coming then to the question of delay, the authorities have long made it clear that an anti-suit injunction is a coercive and far-reaching remedy, and that applications for such relief must be brought promptly. And that's because delay in making the application causes prejudice not only to the respondent, but it also increases the risk of wasted effort by the foreign court, the onshore court in the present case. And I refer you to the observations of Mr. Justice Walker in SR Shipping and Bank of China. The report begins at H1068, but I would invite you to go directly to H1085. So in paragraph 43 begins with a reference to the first instance decision in Ecobank, which I will come back to. But he says, I consider that the approach adopted by Mr. Justice Knowles is supported by strong public interest in requiring that those who seek an anti-suit or anti-enforcement...
Which page are you on? Sorry, Ms. O'Sullivan.
I'm sorry, it's 1085 and the PDF. It's in the bottom right-hand corner.
Thank you.
Paragraph 43. And I was just beginning to read from the third sentence. Moreover, I consider the approach adopted by Mr. Justice Knowles is supported by strong public interest in requiring that those who seek an anti-suit or anti-enforcement injunction should act promptly, even though, on the facts of a particular case, there's been no detrimental reliance on the delay. That does not mean that parties must rush to court prematurely. The starting point is that it is generally desirable to resolve issues speedily. Moreover, there are significant dangers to the interests of the parties and to the public interest if applications for coercive relief are delayed. If such applications are made promptly, they're inherently likely to be much less complicated than will be the case at a later stage. Where a party seeking coercive relief does not act promptly, the other side is likely to be understandably aggrieved by the delay. An anti-suit injunction is a particularly intrusive form of relief, barring a party from access to justice in the forum that it would prefer. In the particular context of anti-suit and anti-enforcement injunctions, lack of promptness will increase the danger that such injunctions, although they are granted against a party and are not directed to the foreign court, will nevertheless be seen as inappropriately interfering with the jurisdiction of the foreign court. And my learned friend also referred you to a passage in Raphael on the anti-suit injunction that's cited in the specialized case at page H1176. We don't need to go back to it. But again, I think, although it's a leading textbook rather than a case, I would accept that that is a fair summary of the relevant principles. I would like to look at a few of the cases which contribute to that summary, starting with Transfield, which begins, well, the passage I'd like to refer you to is at H1153. So in this case, the anti-suit application was actually refused on the basis the court was not satisfied to the necessary high probability that there was in fact a binding arbitration clause. But the judge said he would also refuse relief on the grounds of delay, and the fact that the applicant had challenged the jurisdiction of the foreign court was not held to justify a delay in making the application for relief. So paragraph 71 is where the discussion begins. I refer to this simply because it's quite a useful account of some of the leading cases in this area. There's reference there to the skier star, and then which itself then refers to the well-known dictum in the Angelic Grace. There's reference to Terpfer and Milino Boschke, and the facts specific to this particular case are set out in 75 and 76, when he says, in effect, we can see at 74 that it was said that it is a party is entitled to exhaust the process of the foreign court before applying for anti-suit relief. And the judge says at paragraph 75, I take a different view. It seems to me it was apparent at the beginning of the year that in breach of the arbitration agreement, if there was one, Xi Jinping was asserting that there was no such agreement and was seeking relief from the Chinese courts on that basis. And the Chinese courts were likely to reach conclusions on the basis of Chinese law. At least there was a risk that they might do so. So that was the basis for concluding that delay in itself would have justified refusing relief in that case. But there's a fuller consideration by the same judge, Mr. Justice Christopher Clark, who had then been promoted to the Court of Appeal in Ecobank and Tanno, on which we place considerable reliance, not least because it's Court of Appeal authority in England. So his consideration of the question of delay begins at H1036. Just to give you a little, sorry, that's the case begins at 1036. Beg your pardon. So essentially, this was an anti-enforcement injunction application. Mr. Tanno had obtained judgments from the courts of Togo and Cote d'Ivoire in breach of an arbitration clause in his contract of employment, which provided for arbitration in London. The proceedings were commenced in April 2014 and May 2014, but it was not until April 2015. I'm sorry, is that? Oh, sorry, I thought your lordship was saying something. The point was that the anti-suit application was only brought a year after the proceedings were launched in the foreign courts and judgment had been entered. And in the circumstances, both the first instance judge and the Court of Appeal refused an anti-suit injunction. Now, there's a lot of this judgment I want to rely upon. I just want to flag up for later readings some particularly significant passages. If one begins at 1052 with paragraph 85,
yes, that's
where this whole discussion begins. And again, there's a recital of the importance of acting promptly. And for later reference, I'd ask you to pay particular attention to paragraphs 85 to 88. And I'd also like you to go to page 1059 and paragraph 106. Actually, it begins at the previous page, 1058. Slightly different point here. I just want to digress because it comes up at this point of the judgment, which is that it was argued, in effect, that comity had no place to play where a party is relying on a contractual forum clause, because it said, well, it's just a matter of contract and you haven't got to worry about offending the foreign court. You just hold the party to its bargain, and so comity doesn't come into it. And he said, he dismissed that, and he said, follow these observations, he's quoted a number of cases, plainly support the contention in a case where there's an exclusive jurisdiction clause or an applicable arbitration agreement, considerations of comity are of reduced importance and may well not preclude the right to an anti-suit injunction. The case is, however, not authority that such considerations are of no importance. So even in an exclusive jurisdiction case, comity considerations do play a part. And as we shall see, they play a weightier part where reliance is placed on the alternative vexatious and oppressive ground. So the key paragraphs in this judgment that I ask you to look at are those from 122 to 137. And I can't possibly ask you to read those now or read them out to you, but I would ask you to mark those up.
Yes.
And I'd like to take you in particular to paragraph 135, which is at page 1065.
Yes.
Yes. Yes, and this is really sums up the submission that I wish to make in relation to the role of comity and its relationship with delay, where he says that he disagrees with the premise that comity has no role to play. Timing is of considerable significance.
Yeah.
Again, it's a long paragraph. I don't want to read it all out. Could I perhaps?
I've read it. I've read it. Thank you, Ms. O'Sullivan.
Thank you. And I'd also ask you to rely on place particular reliance on paragraph 137.
Yes.
So he says, whilst recognising delay is not necessarily a bar to relief, and the importance of upholding the rights of those who are beneficiaries of exclusive jurisdiction agreements, I do not regard the cases subsequently decided by this court as rendering that statement inaccurate. And that, of course, is his own statement in Transfield Shipping that comity calls for challenges to be made promptly. So that is Ecobank and Tano. I want to look very briefly at another case in which an application for an anti-suit injunction was refused on the grounds of delay. That's ADM Asia Pacific Trading. Begins at 1022, but I'd like to take you to page 1026 and to paragraph 28, where the respondent to the application adopted the course that we've adopted, which is accepting that the standard for the grant of relief is met without conceding it and asking the court not to decide it. And so, as you can see in this case, the judge is prepared to make the assumption, but without deciding, that the foreign proceedings were brought in breach of the clause. And between particular interest, we see at paragraphs 33 and 34, particularly 34, where the judge observes that the strong reasons point is different from the general discretionary considerations that apply to any application for an injunction. So the essentially strong reasons essentially relate to justifications for suing in the foreign court. And as he says, doesn't subsume or exclude issues relating to delay or other general discretionary considerations. And at paragraph 55, which is at page 1034, you will see that he says, paragraph 55(1), it's self-evident the prompt application for an anti-suit injunction would have been one made shortly after service of the Indonesian proceedings on the 26th of May. So again, obviously all cases turn on their own facts, I accept that, but the tenor of the court is to expect the parties to issue their applications for anti-suit injunctions as soon as the foreign proceedings have been served, and not to hang about for a year. Now, turning to the alternative ground, because as my learned friend, in addition to relying upon the exclusive jurisdiction clause, there's the alternative to foreign cases where it said that the conduct of the respondent is vexatious and oppressive or interferes with the administration of justice. Now, we don't accept those submissions, but we invite you to proceed as with the exclusive jurisdiction clause on the basis that a sufficiently arguable case has been made out, but you don't need to decide it because you should decide this, you should refuse the relief on the grounds of delay. And the only point I want to make about these cases is that where you don't have a jurisdiction clause, there is an even greater danger that delay will lead to an infringement on the principle of judicial comity. And we rely in particular on a quotation from the judgment of Lord Justice Toulson in the Deutsche Bank and Highland case. We set it out in our skeleton, but I will take you to it at H206. And in particular to the passage at paragraph 50, which is H219. I mean, this whole paragraph is a magisterial summary of the key principles that apply to the grant of anti-suit injunctions. But for present purposes, we rely particularly on subparagraph 5, where the judge says an anti-suit injunction always requires caution because by definition it involves interference with the process or potential process of a foreign court. An injunction to enforce an exclusive jurisdiction clause governed by English law is not regarded as a breach of comity because it merely requires a party to honour his contract. In other cases, the principle of comity requires the court to recognise that in deciding questions of weight to be attached to different factors, different judges operating under different legal systems with different legal policies may legitimately arrive at different answers without occasioning a breach of customary international law or manifest injustice. And in such circumstances, it is not for an English court, in this case the DIFC court, to arrogate to itself the decision how a foreign court should determine the matter. The stronger the connection of the foreign court with the parties and the subject matter of the dispute, the stronger the argument against intervention. So I say, therefore, that delay is even more significant where the application is made on the alternative ground, not relying on the exclusive jurisdiction clause, because of the greater engagement of comity in an application of that nature. Now, I just want to say something brief about the application of the principles and the facts of this case. Before you get into it, there's quite obviously been a significant delay before we get into the reasons for it and whether it's excusable, because this application was issued over a year after the claimants learnt that the Hadif defendants had issued the Dubai onshore proceedings and submitted a petition to the JJC. Now, I obviously don't criticise them for not making that application earlier. They couldn't have made it until they were aware of the existence of the proceedings. But they could have taken steps subsequently. They had, in effect, they had two alternative and incompatible routes in my submission. The first was to roll with what had happened, in effect, treat the practice of the courts of imposing a mandatory stay as something that was beyond appeal or argument, and leave it up to the JJC. And that is what they chose to do. Repeatedly, the submissions made on 17 occasions to the Dubai court for stay were on the basis that it was the JJC which ought to be allowed to decide a conflict of jurisdiction, not that there was no conflict for it to decide. So the alternative was for them to put in an appeal against the stay imposed with some reluctance by Justice Cook, and then obtain the lifting of the stay and then make this application. Now, and the point is made by my learned friend that, well, that might well have taken considerable time. Yes, but in that case, they could have said that that delay in getting an appeal on, or getting an appeal heard, or judgment handed down, shouldn't count against them. They'd done everything they could to act diligently. But they didn't take that course. Instead, they decided that the practice was something that they wouldn't challenge, and they would go along the JJC route. And in effect, they took a different view from the legal team representing the Lackhan applicants, who decided that they would challenge the practice. So these claimants took a view. They made a judgment call. In the light of the Lackhan decision, it turns out to have been the wrong call. But that doesn't amount to justification for delay. I mean, it's rather like those cases where the applicant decides actually it will exhaust all its remedies in the foreign court, and if that doesn't work, then come back to the home court for an anti-suit injunction. And to say now, as my learned friend does, that, oh, well, they were entitled to wait for the JJC to issue its decision, and that's why they were entitled to delay. I mean, they're really trying to have it both ways, because they're coming to this court saying it should lift the stay on the basis that the JJC should never have been asked to decide conflict in the first place. There's certainly no conflict. And on the other hand, they're trying to justify their delay by saying, oh, well, we were entitled to assume that the body entrusted with the decision would have made its decision more promptly. And they really can't have it both ways. So we say that had they chosen to go down the appeal course, they would have either been able to make this antecedent application much quicker, or if they hadn't, they would have had a cast iron reason for saying to the court, look, we did everything we could, but circumstances, listing, or whatever, were against us. But they didn't do that. And then there's been very little said about what has happened since the Lacan judgment was published. And it's dated the 8th of April. And we've been assuming that it came out close to that date. We don't have precise information as to when it was.
I don't think that's actually right, Ms. O'Sullivan. I think there was delay. It's not, as you can guess from the names, they're anonymised because it's an arbitration case.
Yes,
and
yes.
For some reason, it took a few weeks to undertake the anonymisation process. So
Right.
I think it was towards the end of April that it was published.
End of April. Well, your lordship is obviously far better informed than I am on that point. But I say that makes no difference to my submission because they should have. I mean, they've shown themselves capable of acting very fast when they finally got round to making the application. This has all come on with tremendous haste. But the absence of swift action between the publication of that judgment and 15th of July has simply not been adequately explained. All that's said by Miss Davis, who has sworn the evidence and support, is, well, we had to take instructions from all our clients, and there are lots of them, they're in a syndicate, and we say, well, that's rather feeble, because if you participate in an international banking syndicate, you do need to have the agility to react fast. If you're going to apply for a form of relief, which everybody knows, you risk not getting if you delay. And also, as we've observed in our skeleton, it seems that they were able to give instructions to their local council to continue with the Dubai onshore proceedings. And those proceedings there have been a large number of hearings. Memorandums have been submitted. An order for document production has been made, complied with in respect of D3, not complied with in respect of the remaining head of defendants. And critically, on the 20th of June, the Dubai court announced that it would be delivering the judgment, which is now thought to be handed down on the 28th of July. So they've had since the 20th of June, and even then it took them nearly a month to bring this application on. And that point, my lord, doesn't just go to this anti-suit relief, it also goes to the question of the timing of your lordship's judgment on lifting the stay. Because really, the claimants are the authors of their own misfortune. If they'd applied promptly after the 20th of June, there would have been time for your lordship to reflect upon these difficult issues and deliver a fully reasoned judgment without being put under pressure to do it overnight. They'd known since that date that this judgment was going to be handed down, but somehow that didn't spur them into urgent action until the 15th, and we've not been told why. And we also say, and this also, I'll come on to the form of relief in a moment, but we say in effect that the horse has already bolted. It's too late to close the stable door in terms of the judgment on the 28th, because it's very difficult to see what can meaningfully be done between now and then to prevent the Dubai court from delivering its judgment if minded to do so. I mean, courts are not controlled by the parties. And as it's not uncommon in England for courts to issue judgments despite the parties discontinuing the claim, if they consider there's some public interest in doing so. I mean, obviously that's a very different situation, but it illustrates the fact that the courts don't necessarily do what the parties ask them to do. It's very much a matter for them. They've been engaged to do it. They may take the view, especially as the proceedings are continuing against the defendant in any event, that they should hand it down, whatever we do. So in summary on the principles, I'd say that on the facts of this case, the proceedings have got to such an advanced route, not because of the urging of the Hadef defendants, but because of the Dubai court's decision to get on with the case, that it would cause prejudice to the Hadef defendants if they were required to stay those proceedings now. And it would also significantly show a lack of judicial comity towards the Dubai onshore court and towards the JJC, which was asked to decide this question over a year ago. So as to the form of relief, we say there's no basis for granting a mandatory injunction here, even if you were minded to grant an interim prohibitory injunction. The grant of a mandatory injunction would in effect bring that it will be a final determination, because if you order someone to discontinue proceedings, that's that. You can't then revive them. So you really have to feel a very high degree of assurance that a mandatory injunction will be granted at trial. But all that's said is that the prohibitory injunction may not be enough. And that's, in my submission, totally insufficient to justify making mandatory order. These, as the cases my learned friend showed you, those are for very clear cases, and there is not sufficient clarity that making only a prohibitory injunction would not deliver the relief which the claimants are seeking, to the extent they can deliver any relief at all in relation to the judgment of the 28th of July. I mean, as I suggested, I mean, if this court makes any order in respect to with reference to those proceedings, it may well be acting in vain, which is not something that the court cares to do. And I think my final point was simply that it was said that refusal by the third defendant to consent to a stay meant that that was relied upon as justifying mandatory relief. Well, I mean, their order is sought against him, and in a sense, I mean, he has a different position. He is entitled to say, well, I have not submitted to the jurisdiction of the IFC court. I have made my fraud allegations in Dubai. I'm entitled to have those allegations decided in the court of my choice, and I shouldn't be required to consent to a stay for the benefit of my fellow defendants, even if we are represented by the same solicitors. And obviously that might give rise to conflict issues. But I mean, it's very unreasonable to criticize the Hadef defendants on the basis that D3, who is in a different position, has not agreed to join his voice to theirs for a stay. Anyway. I'll just check and see if I'm being asked to make any points, but subject to that, those are my submissions. Yes. I did.
Thank you. Yes. Senators O'Sullivan, Mr. Montague-Smith.
Very briefly, if I may.
Can't hear you, Mr. Montague-Smith. You might have put yourself on mute.
I pressed it twice. I'll find myself, Your Honour, the appropriate charity of my choice, unless you'd like to nominate one. I was going to say, I'll be very brief. I'll take it in the order my learned friend did, and I'll just touch on some of the points that she raised. The first point, it was suggested that the very few cases which have considered an anti-suit injunction injuncting Dubai courts, and I wouldn't necessarily disagree as a summary, but firstly, it's not right that Brookfield was not concerned with a Dubai court case. That's just not right. The case that in respect of which the injunction was sought was a claim in the Dubai courts. Okay. And it was in that case that Justice Cook said, had that been an infringement of the arbitration agreement, I would have made that order, and I wouldn't have been that bothered about. It was only in the other circumstances where he wasn't, if he'd found that he wasn't the supervising court, that he would have been very cautious about making any sort of orders of that nature. There are other cases, largely in the arbitration sphere, where orders of this nature have been made. Unfortunately, they're not reported, and we don't have any judgments in relation to them. Sad to say, but I would say that in cases where there is exclusive jurisdiction agreements or arbitration agreements, one cannot detect any reluctance to go down this particular route. My learned friend referred to the Talim case and the Azam case. Azam obviously refers to Talim. There is one particular passage in Talim, again, I'm afraid I was in this one, it's at tab 63, and it was a very, very early case. I think the first attempt to obtain an anti-suit injunction, in that case on the vexatious and oppressive ground. And I just direct you to page 1140, paragraph 20. The then Deputy Chief Justice was saying that the problem arises because it's not impossible that in some circumstances the two courts might take different views as to the effect of that legislation being the judicial authority law that gives jurisdiction. If that proves to be a real problem in practice, then some steps will need to be taken in order to solve it. But as I've said, it seems to be essentially unhelpful to attempt to solve it by the grant of anti-suit injunctions at this stage, a fortiori in this case, where the problem may never, in fact, arise. So, if we can put it this way, unfortunately, the problem has not resolved itself, and no good answer has been found to that problem. The other point, as I say, is that that case and the Azam case are not cases involving exclusive jurisdiction agreements or arbitration agreements. Those were vexation and oppression agreements. It was really about asking the DIFC court to preempt interpretation of the judicial authority law. And as my learned friend has taken you to certain passages of cases in the Court of Appeal in England, comity in some cases has said not really to be a consideration, in others it's said to be a reduced consideration when you're dealing with jurisdiction agreements, because all you're being asked to do is enforce a party's contractual promises. So I'll just turn then briefly to deal with respond on delay. Delay, the refusal of anti-suit relief as a result of delay is not a punishment. It's not intended to say, well, if you don't act promptly, you're not going to get your order. The main concern is what impact does that delay have on the foreign proceedings, in this case the Dubai court proceedings. You can see that from the SR shipping case. Very briefly, if I take you to page 1088 of the bundle, tab 60, and you'll see there a summary of the principles at 52 and propositions that were being advanced. I think they're propositions that are being advanced on the basis of the provisions in Raphael, which my own friend, I think might be a slightly different passage. But at 52.1, what was being said was that the length of delay in itself is of less importance than the extent to which the foreign proceedings have progressed during the delay. And that reflects what was said in the Raphael passage that I took you to, and my own friend agreed to. And one has to bear in mind, of course, there are cases where anti-suit injunctions have been refused because of that sort of delay. But the sorts of cases you're dealing with, and my own friend took you to, for example, EcoBank was an anti-enforcement injunction. So the case had got all the way to judgment, and they were saying you mustn't enforce this injunction. The ADM case that Your Honour was taken to was dealing with a case where the claim had been going on for 2 years, more than 2 years, I believe, and there'd been judgments and there'd been appeals, and there was extensive degree of engagement by the courts. So one has to bear in mind, this isn't about punishing delay. This isn't about an election between two inconsistent courses of action. This is about, is there a fair criticism? And if there is a fair criticism, what would have happened if what is being suggested should have been done had been done? And what is the difference in terms of how far the Dubai court proceedings have advanced as a result of taking one course but not the other? So I don't accept the criticism. I won't repeat my position in relation to the criticisms. But what we haven't heard anything about is actually what difference it makes. Because my learned friend accepted that an appeal would have taken time. He didn't really deny what I said about the timing that would have occurred. So you'd be looking, really, even if you got to a decision in around the same time as Lacan, if you got one a little bit earlier, you would have been looking at an anti-suit injunction being heard in sometime in May, June, maybe, at the earliest. It's just not likely that that would have come on any sooner. So one has to look, what has happened in the Dubai courts since that time? All of the activity that's relied on is in relation to things that happened by March. So 21st of March, I think, was when the defendants filed their submissions on fraud, and then there was a subsequent response to that. But in terms of prejudice and in terms of actually what impact has it had on the Dubai proceedings? There really isn't a case on it, as far as I can tell. As I say, it's not about punishing for delay. It's about looking at the consequences, looking at what happened, what would have been resolved. So that part of the criticism is, all right, well, once the judgment once the judgment was listed on the 20th of June, we should have acted more quickly. That's what's said. Now, that might be a criticism if it was fair, which I don't accept, but if it was fair, which would be made in relation to this hearing, about how this hearing was organised. But here we are, we're making, Your Honour's making the decision, and the issues are the same. When we're dealing with the actual question of whether delay should be a response to the anti-suit, what difference has it made in practice since the 20th of June, if this application had been brought on 2 weeks earlier? My learned friend said it was almost a month. In fact, there's 3 weeks, as I read it, between the date of the application. So if it's being said it should have been, this application should have been brought on a week earlier, this application should have been brought on 10 days earlier, is it genuinely being said that something has happened in the Dubai courts in those 1 week, in those 10 days, that has made any difference and increased the prejudice or the problems of comity in relation to this? There's just no facts, if I can put it like that, to back up a submission of that nature. In relation to the form of the order, it said, well, it's not enough for my case to be a prohibitory order may not be enough. That can't justify, it said, a mandatory order. I just remind you of what was said in specialised vessel services at paragraph 86. I showed you the test that was applied there. The test was in terms, if a prohibitory injunction, quotes, may not be enough. That's sufficient. That was the test. So that is in terms sufficient. And then my learned friend said, well, it's not fair to criticise the Hadith defendants for the third defendant's stance. I don't criticise them for it. What I say is that the effect of that stance you can take from his refusal to grant an undertaking, to give an undertaking, that he's going to oppose a stay, and therefore there is strong grounds to think that a prohibitory injunction may not be enough. In terms of actually what we want, the order itself that we have drafted is in the ordinary form. So you'll find it at B4, page 11. Paragraph 3 says the respondents must forthwith take all steps necessary to discontinue their claims in the Dubai proceedings. They don't have to guarantee that result. Everybody knows what you need to do to discontinue proceedings in the Dubai courts. You need to file a memorandum saying we withdraw those proceedings. If they want that obligation to be recorded in the order, it can be added. There's no real difficulty in relation to that. So, Your Honour, unless I'm told that there's anything else that I need to revisit in the next 3 seconds, those are my submissions, and thank you.
Right, thank you. Well, thank you. I've been giving some thought to what should happen now, obviously. The issues that have been raised are of considerable complexity, both in relation to the stay and in relation to the anti-suit injunction. And I know that the reason the application was brought on urgently is because it appears that a judgment might be delivered in the Dubai courts on the 28th of July. But I do think there is force in the point made by Ms. O'Sullivan, not so much in respect of whether there's delay that mitigates against the anti-suit injunction, but in relation to the timing of my decision. The reality is that the banks were told of the pending Dubai decision on the 20th of June and didn't bring these proceedings until the 15th of July. Had they brought the proceedings a week or 2 weeks earlier, then there would have been much more time to give orderly consideration to these matters. So I don't think I should allow, in those circumstances, I don't think I should allow myself to be pressured into an increased risk of error by making a hasty decision. And so I don't propose to give a decision in time to enable anything to happen between the 28th of July, between now and the 28th of July. So I will reserve my decision, and I will call for the transcript so that I can give full consideration to the arguments that counsel have raised. I'm part motivated by, in taking this course, because of the points that both counsel have made with respect to the importance of these issues for the operation of the court's jurisdiction generally. And as I've mentioned before, this is the third case of this kind that I've heard in the last couple of weeks. There are probably more in the pipeline. It's a very important issue. We need to get it right. There is a risk of inconsistency if I rush, and that can't be in anybody's interests. So I think it's better for me to take time to get it right. So I will reserve my decision. What that means, Mr. Shehan, is that if you wish, you can give me a document within 7 days, which I think will be the 7 days from today will be the
Your Lordship, are we sure all of them are there? I think they all got disconnected.
Oh, Mr. Shehan, can you hear me?
I just wanted to say a few words, but if they are not there.
Oh, yes, you can. What would you like to say?
Voice is breaking, and I think others got disconnected.
Oh, well, I can hear you.
I'm still here.
Other councils are there, or they got disconnected?
Yes, no, other council are there.
Other councils are there. Okay, I don't see them on the screen. Yes,
Okay.
Your Lordship is right. I'm just pointing out the justifications given by my learned friend to justify the delay. It doesn't hold water because.
But Mr. Shaheen, no relief is sought against you. No, the anti-suit injunction isn't sought against you, so you don't need to worry about it.
I'm not able to hear properly. There is the voice breaking.
All right. Well, let me tell you again. The issue about delay in bringing the application of the anti-suit injunction doesn't affect you or your client because
it's not
no
injunction is sought against me. I'm talking in general about his justification of the timing of the application. That is my main contention. I've not been able to contact my clients or take instructions.
Yes,
On
well, I understand that. And that's why I'm going to give you the week that you sought in order to put a document before the court.
I couldn't hear it fully, but I'm trying to say.
Well, let me say, you said to me earlier that you would need a week to take instructions and put your client's position to the court. I will give you that. I will give you that week.
Understood. Much obliged.
You have until the 2nd of August to put on any written submissions in relation to the application to set aside the stay.
Thank you very much, Your Lordship.
Do that in writing. I will review those submissions, and if I feel that there is a need to give the other parties an opportunity to comment upon them, I will. Or if the other parties, having seen them, feel that they should comment upon them, then they should do so promptly. Because I do hope, obviously, to get this decision out as promptly as I can. But so, Mr. Sheen, your clients can have 7 days to put on those submissions. And I'd also give liberty to any party to notify me of what has happened in the Dubai courts during the time my decision is reserved. If they wish to do so, there's no obligation to do so. But if you do want to tell me what's happened, you think it's relevant, then of course you should put that information before me. But otherwise, I'll reserve my decision and give it to you as soon as I can. I'm sorry I couldn't do it any faster, but these things, it's important to get them right, I think.
Understand. Thank you.
Yeah, right. Thank you very much.
Thank you, my lord.
Good. Thank you. Thank you. Good evening. Or, all right, morning, wherever it is, whatever time.
No, afternoon, but yeah, good evening.
Yeah, okay. Goodbye.
Bye.